Are we gonna let Aaron go first, or you're gonna?
I would like to welcome everyone to the workshop. We have one item on today's agenda. It is proposed constitutional reform. Specifically, Rob would like us to pass an amendment from the Constitutional Reform Committee that was created several years ago. We've had legal go through it, but to begin, we're going to have membership input on this document, and it's just about constitutional reform in general. You guys can talk to us as long as you want, within reason. You know, if it goes on to about an hour, you know, I'll probably cut you off. But, you know, say whatever you want to say in regards to this, what your goals are, long-term goals for our government. If you want to see a 2-branch, 3-branch, what you guys want to see out of this. After that, it will be a workshop with the board. So if anyone online, being a tribal member, would like to speak on this, we don't have anyone physically here in the room, put your hand up on Zoom and we'll call on you. Okay, so I don't see any hands up. So Aaron Schlehuber, if you want to preface this conversation, I'm going to give you the opportunity to right now.
Thank you. So it's a heavy document. I think it's probably best to start perhaps just up on top where it says drafting notes and maybe give you an idea of where we're coming from as we review this. So each board member and each tribal member is more than likely looking at this project through a different lens. And that's true for the attorneys. We're looking at this through a different lens than probably you are. My goal in reviewing this project is to, A, provide the board and or the membership did you do it wrong? No. My goal is to provide the board and the membership a document that accomplishes what it is you are looking to do. And what that means for an attorney specifically is we need to be very intentional in our language, eliminate the ambiguities, and not by a mistake, whether it's intentional or not, create problems down the road that result in all of us spending time and money litigating out certain things. That is, frankly, quite a bit harder than it sounds. I've spent over 20 years writing policy procedures and code for Sioux Tribe. And even today, things will come up. Someone reads something I wrote in 2002, and they interpret it completely differently than what I meant. I'll read it and think, well, that's a pretty good paragraph. I don't know how they see it that way. That's fine. And then I'll read something I wrote in 2002 and like, wow, that was really, really bad. I don't know why I did that. So our goal here is to review each line very carefully and make sure it very, very clearly matches our intent. As I understand it, focusing on the word intent, is there are a couple of intentions here. The intentions, as I understand them from the board, or a majority of the board, is that a tribal member who is aggrieved or takes issue with something that the tribe or the tribal government has done has recourse over in tribal court, that they are able to file an action and have their grievances heard, and from their point of view, hopefully get an outcome they're looking for. So it seems to me, in listening to this project for the past several months, the number one goal is allowing a path for a tribe member to sue the tribe. I think that's pretty clear. Down below that, the intent of the board and/or the membership starts to get a little less clear. It becomes more fluid because everybody has a slightly different idea in mind, and that's where it gets a little bit hard. So number one, we want the membership to have legal redress in court. That's clear. That part is not difficult to obtain. How we do that is a little bit different. So we're going to talk about how this document stands up that court, what that looks like, how it functions. We'll talk about the problem with elected judges based on, I guess I'll say, our geography, that reality, and how we handle that. That part is all clear. What's less clear to me is the following two areas. By creating the third branch where we separate the tribal board, I'm going to use the old terms versus the terms that are in the document just for my ease. Separating the board from the chair's office, having those two be separate. That is much trickier and frankly is going to need much more discussion and careful thought than allowing the membership a path over in the court against the tribe. What I'm particularly worried about, and you'll see it littered through all the documents I've provided you, is when we separate the tribal board from the tribal chair, the blunt fact of the matter is we are opening up that relationship to litigation. To be more blunt, and I don't mean to offend anybody, but I think in this conversation we just have to use the words that are accurate. Because our politics are so aggressive, because our politics are what they are, and they've been this way for a very long time, and I see no reason to believe they're going to change. We have to accept the reality that there will be litigation across the street between the board and the chair's office. Any tribe that has a three branch, for the most part, it just deals with that reality. So we need to approach that carefully. We need to understand what it means. We need to be ready to handle it when it comes. We need to make sure our internal systems are able to adapt to it. And perhaps more importantly, we need to ensure that whatever we put on paper when it comes to the board versus the chair, that the system allows for continuity of government, continuity of services, the lights stay on, services keep flowing. When I say that, what I'm flashing back to is the last week I've spent the bulk of my time on the phone with lawyers that work for tribes that have some kind of division of powers, whether it be three branch or two branch. There's examples all over the country, and just kind of taking their input. And having those conversations, one item that floated a bit to the surface is because there tends to be so much litigation between a board and the chair, a lot of the actual decision-making ends up being over in the court, whether it be a budget, whether it be how to structure some executive decision, whatever the case may be, you end up having to wait for the court to make that decision, which maybe isn't really fair to the court, but the court becomes very active in the conduct of government. So you need to make sure that the system we have in place allows us to keep functioning, lights stay on, while the court handles whatever disagreement there may be between the board and the chair. And I'll probably mention right now, we haven't talked about it a lot, but I know it's come up. Going into this, I didn't really have a strong opinion on three branch and how we structure it. You know, my thought was we'll just deal with it. After some conversations this week, I very openly tell you, I think we should have a discussion about a two branch. If our intent is to give members access to the court, that can be done. That's our goal, we can do it. the path we're on right now with the 3 branch that sets up this path of litigation between the board and the chair, I've not heard anyone indicate that part of our intent is to separate those two in such a way that we all end up in court. This document has the potential to set up a scenario where we're constantly fighting via litigation, and I haven't heard anybody say that's what we're looking for, and I want to really put a finer point on that. It didn't really dawn on me until just really maybe even yesterday. I spent a lot of time talking to a lawyer that works for a tribe in Michigan that has 3 branches, and I don't want to say their name, but I think their name came up the other day. And they struggle mightily with this. It's their current court docket is just Council versus Ogama. I think there's 4 active cases. It's constant. I know. That's okay. The docket's public. And I spoke to some other tribes that have that 2 branch, and the phone calls are going back and forth. In the 2 branch, the members get their say. The members can address the grievance, but the leadership isn't put in the place where there's that constant litigation. So as we go through this, I just want to flag, if our goal is to give members access, we can do it. But under the current process, we are setting up a system where the chair and the board will be in litigation. I don't care about the cost. I don't care about how we structure competing legal departments. That all can be done. What I'm more particularly concerned with is I am told by people that live it, if you have rough politics, setting up a system where your executive office and your legislative branch can litigate against each other may not be the best idea, and that comes from tribes that have politics, frankly, that may not be as bad as ours. So it's something I want to get on the table to get us thinking about it.
Okay, Aaron?
Okay, so I was hesitating on how much I'm going to talk today because either this is going to happen or it's not going to happen. People already know what they're going to do. They already know how they're going to vote. And I think there's a chance that it might happen, but my hope today is that we don't have a bunch of justifications to not move forward. So if the founding fathers of the United States government, and again, this argument that that's the white government, and we should ignore all of that is total nonsense because we're all Americans, and the United States government was created based on the Iroquois Confederacy and based on Indian values and having a separation of powers. Because the people who fled, the first wave of immigrants who fled Europe, came here because they were under a dictatorship or under parliament or whatever they want to call it, but not the form of democracy that we have with the separation. So if we make a choice not to enact a 3-branch government because we're afraid that the remedies for keeping each separate branch of government in line will be exercised, that's not a valid reason. It might be a practicable sort of cautionary tale, but it's not a good reason to say that we shouldn't have a remedy for the legislative and the executive branches because they're going to use that remedy. What I've seen with the 3 or 4 tribes that have a separation of powers, that have had the wisdom to enact a separation of powers rather than just accept an IRA constitution like we had to, like we didn't have a choice. I've read Mr. Hatch's letters back and forth with Interior, Fred Hatch, and also Joe Lumsden, and old Fred Hatch. So they're not senior and junior, there's old and young Fred Hatch. Young Fred Hatch was the attorney. And basically, the BIA said, adopt it this way or we're not going to put it out for a vote. And so we didn't have a choice. I saw in back and forth in the letter the desire to have a real government and not an IRA corporate charter. But again, the argument that we shouldn't have remedies between the executive and legislative branch because they might exercise those remedies is not a reason to not enact a separation of powers. Also, I've been good friends with the chairs of Little Traverse, Little River, Pokagon, and Huron Band for many, many years, and have watched the challenges back and forth. And they're valid challenges. They're challenges to ferret out what is the authority of the executive branch versus the legislative branch. And so here's the thing. We can enact a new constitution and then just kind of get into this fight back and forth, or we can be conscientious, good elected leaders, and we can enact legislation ahead of time that can anticipate how those remedies and make clear what those separations are. You know, we're struggling right now, and I know that we fell short last week of the delegation of authority, but the board was not willing, the majority of the board was not willing to delegate authority to the chair. So that either means that they never want that delegation to happen, or it means that we're going to adopt a separation of powers, so we don't need to do it yet. So it's maybe either one of those two. But if it's the first one, not the latter one, that they never want the chair to have separate authority, then the quandary that we're in with team members, executive team members, not knowing who they report to, being unclear of who's their supervisor, trying to decide which 7 butts to kiss to keep their job. You know, that's my old saying is the 7 butts you kiss today will slash your throat tomorrow in a heartbeat. I've seen that many, many times. And so rather than adopt a 3-branch separation and just kind of wait for the litigation to come, why don't we conscientiously think about creating the parameters by which the executive branch has their authority, the legislative branch has their authority. So I will not support and I will not vote, and I'm not changing my vote on a 2-branch. That's complete nonsense. That's not a separation of powers with a true government. There's forms of that across the world that show that that's not legitimate. Also, some of those conflicts that have happened with those tribes that became tribes post-1998 have worked through most of those arguments. And they're not having the kind of vitriol and the kind of conflicts that they had about 10 or 15 years ago. So, and I can get those in writing. I can, you know, I'm friends with the legislative branches and the executive branches. They're just not there anymore. But like Schlehuber said, we're different. You know, we're waiting for trying to decide how we can agree with the chair, how we can undermine the chair, you know, and how we could not allow the chair to supervise the day-to-day operations of the tribe. A 13-branch management board is just complete nonsense. It doesn't work. I mean, in the examples, I won't give you specific examples, but we have workshops with executives and we have a bunch of conversations back and forth, and this is something that just happened last week. And then when we're done with that meeting, it's not clear what the manager is supposed to do or what the executive is supposed to do. So we have to kind of guess at what board members meant, what they said, and that leaves management and CEOs and qualified Indian people in a position where they don't know whether or not their job's secure, whether or not they're going to get fired if they look at somebody the wrong way. So I'm glad that we're not abandoning entirely the right for citizens to challenge the action of their government, because we should all have due process rights in this tribe. But I think that we can allay any concerns with fights between the executive and legislative branch by being intentional and enacting legislation to prevent that from happening. And if the fights happen, that means they have to happen. And then once the courts decide, if the legislative branch is out of hand, then they can keep their mouth shut. If the executive branch oversteps and then the court decides, then the executive branch is going to have to learn to do their job better. So the argument that we shouldn't have a separation because we're afraid of litigation to ferret that out is, to me, is not a valid argument. I'm glad that you're cautioning us with it, but I don't believe it's a valid argument not to have a 3-branch separation. Thank you.
Tyler.
Just a question, Aaron Schlehuber. The tribes that you have been speaking with, you said 2-branch government and 3-branch. Which ones in our region, are there any specific ones in our region that we're looking at just to see, you know, as an idea what this might look like, whether it's successful or non-successful, just from an outsider's perspective, just viewing them?
I've spoken to let's see, LVD, Little Traverse, Grand Traverse, Gun Lake, Pokagon, regional, locally.
Which ones of those are 3 and 2? I'm not familiar with their government structures.
Grand Traverse, Little Traverse, and LVD have versions of 3. Pokagon and Gun Lake have a version of 2.
Okay, thanks. That's all.
That's just the ones locally I spoke with.
Okay.
No, that's good. That's good to know that there's immediate sources out there that we can look at.
Okay, anyone else? Okay, say a couple things on it then. So I frankly don't think that the board is honest when they say that they want a separation of powers. So there's a resolution on at the last meeting that would have given the chair's office limited delegation of authority, and it's less authority than that's in this amendment that people claim to support. So I'm just going to throw that out there right now. Regarding suing the board of directors, I totally would when it would be necessary. I mean, I can think of 88 million reasons why to do it. I mean, come on now. I mean, the board of directors has gotten the tribe sued left and right. And you're laughing about this because you know it's true. You know what I mean? You're probably going to get in trouble over it. I probably will too, if we're being honest. But so it's good that we're pointing out that it's very important that tribal members have standing in tribal court. But at the end of the day, there also needs to be a check and balance on the board of directors. I mean, I've won multiple chair elections and landslides. My supporters, the constituents of this tribe, expect there to be some sort of oversight over the board of directors. And what I haven't seen so far from everyone that's campaigning on this issue is, if you are going to fractionate power, what power are you pulling away from you? Because if there's a check and a balance on your authority, you have to give some of it up. I mean, it's plain and simple. So, I mean, we know that there's a powwow with the key employees, and we know that there's a problem with management, all right? And we're going to flesh some of that out when we have our survey. But we also know, if I were to survey the board members here and ask them, how many key employees do you supervise? A lot of them are going to fail that quiz. And if I go further and I say, list their names, they're going to fail at that too and say, hey, tell me how this employee's been doing lately. And that's just being honest. I mean, we all know that. That's just being honest. So if we're going to do 2 branch, which I'm on the fence about, Aaron, I will consider it, there has to be some way to put a check and a balance on this body, to where we're not going to get the tribe sued, to where we're not going to lose downstate casinos, where we're not going to put in jeopardy us being able to pay our employees because a lay board thought that they had a good idea a couple Tuesdays ago. So, and that's just being honest and real. So if we're doing 2, there needs to be something built into this to where there is a check from that kind of behavior. And I'll say this as well, the board of directors has no business being in operations. The board of directors should not be involved in appeals processes moving forward. I mean, we had to strip down the amount of board members on an appeal from 3 to 1, because unless it's a board member's family member, supporter, or friend, no one cares and no one gets on it. So it's a political system we live in, and that's unfortunate, and we do have to do better. So moving forward, do we want to go through this document redlined? Yeah? Okay, let's start.
Before I start the document, Aaron brought something up and Austin just brought it up. I should mention, it also didn't dawn on me until very recently. Again, I'm going to be very blunt today. I don't mean to offend anybody. It's just easier. There's been a back and forth for a while on the who is going to oversee the key employees. Another way to phrase that is who is going to, be the lead executive for the tribe. Pick a word. I did not realize that discussion tied so heavily into the constitutional discussion. I just hadn't plugged those 2 together. Now that I see there's a relationship there, I just want to say right out, whether it's 2 or 3 branch, there is a way, if the board so chooses to put forth that document, to build executive leadership into the chair position. You can do that even in a 2 branch. So I've just recently, actually I think yesterday, internalized how the executive leadership is tied into that process. I didn't really see it previously. So just to flag that point.
Okay, Aaron?
Okay, so I know some people, it's like hearing fingernails on a chalkboard when I speak, but I have 22 years of experience in tribal government, and before I ever got elected, I had a graduate degree in public administration, understanding governance. And so I have the experience of both being a board member, but then also being the executive for 16 years, which 4 of those were, or maybe three of those were without the CEO or delegated duties. And so what I've seen, and I'll be careful not to mention names, is when board members disagree with decisions that are made administratively, I've witnessed them strip the chair of authority, but also delegate the executive director temporarily. And then when the executive director doesn't give the answers that the board wants, then take that authority away from the executive. One example was the health director reported to the chair at one time, and then they didn't like what was happening there, so they delegated it to the executive director. Then they didn't like the executive board, sort of a loose sort of oversight. And when they didn't like the executive director's oversight of the Housing Commission, Housing Authority Director, then they took that away from the housing, or from the executive director. And so it's kind of like this movement, this sort of fluid movement. As soon as the majority doesn't like the way management's happening, from on high, from this lofty perch, they upend and change the whole structure. And it creates confusion, it creates instability, it creates insecurity in our executives in whether or not they want to work here. If you look across the tribe, we only have 1 or 2 tribal members that are in executive positions. And the reason for that is because they have told me there ain't no way in hell I'm working in that structure without any kind of due process or any kind of protection. And I'm not working for 13 people. And this might get people mad, and I don't mean it to get people mad, but when I first got elected, I had a graduate degree. I had experience in administration, but I came in with a humble focus because I knew what I didn't know. But that's not the case for everybody. Some people get on our board, they've never worked anywhere else in their life, and then all of a sudden, they're executives, and they know how to supervise executives, they know all about finance and banking, they know everything. And rather than that, one of our teachings, one of our Sen grandfather teachings is humility. And that you come into something and you say, okay, I don't really know all of that. I'm not a casino person by trade, right? So I've been deferential to that. Rather than think, okay, I know when to fire people, I know, who to supervise and how to supervise. But that's why we need a separation between the executive branch and the legislative branch, because lay people should not be supervising administrations. If they have the experience, and over the years, only a handful of people have had administrative experience where they've supervised executives and multi-million-dollar budgets. Managing your own checkbook is different. And I don't mean this to be derogatory, but what we should do is when we hire the executives, we should trust and rely on them, trust but verify. They should supervise, but we shouldn't be, and we have people that always say, I don't like micromanagement. They publish that in their articles all the time, but then they're the first people to want to get right into the detail and know how policies were followed or not, and providing separate remedies for people that don't exist. That's a contamination. That's not the way it should be done, because then everything's arbitrary and capricious up to a majority of the board that make decisions. So that's why we need a separation of powers, so that when the people of the tribe elect the chairperson, the legislative doesn't have to like it. You got to line up and you got to support the chair, or you got to do your job without hate. Because when I was chair, there were people that just hated it. And everything I tried to do, which was good, I balanced the budget every year that I was chair. We got millions and millions of dollars from the federal government, and it wasn't good enough. No matter what I did, it was wrong. And if you want to be chair, go out and get the qualifications, run for the chair, and then become chair. Don't try to be chair from a legislative seat, because that doesn't work. It just confounds our government and messes everything up. That's where all the animosity comes from. So
Okay,
I'm
Bridget.
going to try to not talk so much today. I already promised myself that. I need a rubber band.
Go ahead, Bridget.
I thought we had possibly discussed that we were going to let him, Aaron Slaber, legal, present this before we had any comments. I don't think we're ever going to get through this. I would hope that people could write down maybe their questions or comments and save it for the end, so at least we could get through the document. So I'm hoping we can do that.
Can you guys stick to that? Save questions, comments till the end? Unless Aaron says this is a good stopping point. You guys want to handle it this way?
I'll get a rubber band too.
I'll get
right,
one
I'm
too.
ready.
So go ahead, Aaron.
All
Yeah,
right.
and if you find a good spot to take a break before we get too far ahead of ourselves, just let me know and I'll call for questions, all right?
Okay. So number one, this document takes certain sections that deal with separation of powers. I kind of opened up with this section just to kind of tell you where we're coming from. Number two, everything red is for all intents and purposes what what Rob pulled out of the 2012 and what I've stuck into the existing document. That's red. Blue are my edits or suggested changes. This part's pretty important. These are limited because I'm not going to go through a big, heavy editing process and start really heavily tweaking language unless a majority of you tell me to. I'll need clear direction before I take that step. Not that I don't want to do it. I don't want to be, putting my fingers into how sentences are structured in this Constitution without my client telling me to. But I have included a couple examples so you can see what I'm talking about. This kind of floats back to my earlier comments where there's poor drafting, ambiguities. Those are all very dangerous things that we need to really clean up. Yellow blocks are just my commentary that refer to the language that's directly above. I tried to underline that language. The yellow block with bold is because I just keep going back to this thing and making different changes. So the one I sent you several days ago is slightly different than the one you got last night and you have right now, noted in bold. All right, let's get into it. In the preamble, for ease of conversation, I don't want to keep saying Rob's because that's not fair to Rob. I'll just say 2012. So in 2012, it's not clear how it was intended to handle bylaws because that kind of language is stretched through the whole document. And when we take the short in 2012 and we put it into our existing Constitution, we do need to take a look at how that interacts with the bylaws. And there's some decisions to be made. I'm not clear the intent originally. What's in the bylaws are all things that need to exist. It really boils down to where we place them. That's fairly easily accomplished. I'm not terribly worried about it. It's just a pretty important thing we can't forget because the bylaws are actually pretty darn important, even though we tend not to refer to them a lot. So let's slide down to the red. I apologize for the purple on my screen. I don't know what I did. I think Ashley touched my computer, and I'll blame her. Source of sovereignty. The members, I'm going to stop right here. Members, people. So in 2012, there were a lot of decisions made on terminology within the tribe. I'm going to touch on that briefly right here. We changed the name of a number of things. Unit was moved to district, board was moved to legislate/council. The chairperson was moved to Ogama, although in this document, the chairperson's referred to in 3 different ways, which is a drafting concern and fixable. Then the tribal member was moved to people. So I just throughout kind of made some modification on those points. It's up to the board if we ultimately want to change the terminology used within our structure or use the terminology we've had really since inception. It legally doesn't matter to me. It's up to you. It's a policy choice. Supremacy. Everything under Article 1, sovereignty, supremacy. These are all pretty normal and good things you want to see in the Constitution. Don't have a lot of concerns. The concerns are, again, going to be in yellow. So this next section, the chair and the court shall cause to be completed and presented to council an written assessment of existing laws within 6 months of adoption of this constitutional amendment. So constitutional amendment shouldn't be capitalized, to determine which laws are inconsistent with this Constitution. This paragraph does not fit here, and this direction needs to be discussed. My concern is asking a newly formed court that we're not going to have in place for a while to, on its own, with assistance of the chair's office, determine what is or is not constitutional. Is it a massively heavy lift, but it has to be done. But what concerns me is there's no recourse of that granting of that immense power unchecked, which kind of runs antithetical to the core idea of putting the court on its own or the separation of powers. At some point, I'd like to look at a different way to do that. Specifically, what I'm concerned about is you have a group of people that's going to decide over the whole breadth of our code what is constitutional, what is not out of the gate. And if we disagree, there's nothing we can do about it. They just may be dead wrong. Maybe beyond that, you're also asking a group of people, because of the number of judges, that just might be new to our systems. There's potentially no historical knowledge there. It's borderline dangerous. I'm going to suggest that as we talk about this at a different time, that a more concerted effort be given, heavily involving in-house staff, departments that work with these things, to have a good say in what is constitutional and what is not. I'm fine with the court having a role, but asking them to on their own do it when they, it might be 5 justices that only do child welfare and don't do finance and don't do gaming. You're asking them to make decisions on areas they just may not really have a lot of experience in, and their decision is final and binding. That's I'm concerned about that process. Item number 1. Section 3, delegation of sovereignty. Government shall exercise all the authority and powers granted by the people. Remember, in this Constitution, that's fine. Reserve powers. Section 4, reserve powers, is one of those very important clauses that carries an immense amount of weight. And as this moves forward, when a tribe member takes issue with something we've done, this is the kind of section that's going to be referred to an awful lot. Powers not granted to the government shall be reserved to the people. This is the core tenet of people like me that tend to be a little bit libertarian. No concerns. Bill of Rights. So scrolling through the entirety of the Bill of Rights, there's nothing major that's a problem here. For the most part, it's quite fine. There are some comments I want to go through, though. You'll see I underlined the word government. My note is this is a legal nerd example of unnecessary language being used that takes a very simple, concise statement and opens it up to possible ambiguity without intent. So my note is, does this include officials, employees, appointees? Minds will differ when you read that section. You can read that different ways because it has the word government and the word tribe together, when each term on its own accomplishes what you're looking to do. When you put them together, it opens up the possibility of someone down the road saying, well, when you said the government of the tribe, you only meant the legislature. Well, that's not what we meant. It's an example of uncareful crafting that we need to be mindful of. So I give you an example. I just said, tribe shall not make or enforce any law which. So when I say that, I know what I mean. Tribe means the whole kit and caboodle. That's the Child Welfare Committee. That's the Conservation Committee. That's everybody. It's unambiguous. So it's an example of when I, up in the top notes, said I've not gone through and done a heavy edit looking for those kinds of little possible things to trip over. This would be an example. We'll go through the rights now. A, infringes upon religious or cultural beliefs. Basic core tenet, prohibits freedom of speech, expression of the press. Another core tenet. C, infringes upon the right of any person otherwise eligible at any time to seek and hold elective office. Again, core tenet. D, violates the right of the people to speak in their privacy and their persons. That's one of the big ones. It's well written. I see no issues with it. Called our Fourth Amendment if you want. E, subjects any person to search the probable cause. Very simple to D. Both D and E work together to offer a member protections from the tribal government being abuses in the conduct of their power against them, particularly through law enforcement and through a criminal or child welfare action. F, subject any person to prosecution more than once for the same offense. Again, a very core tenet. G, I want to talk about G. G makes me extremely nervous. Discharges any person from employment without due process, or takes any private property or interest in private property for public use without due process and just compensation. So first, just these are two distinct things that should be pulled apart. So I want to focus mainly on the employment comment. So when I read this, I can't help but read it to that it requires a hearing for all terminations. We have around 350 a year, and this will grind the employment practices to almost a halt. It will make it very hard to conduct business if this is read to require a hearing for every single termination.
Go ahead, Aaron.
Are we doing a review of the 2012 entire document, or as requested, Rob's proposed amendments?
Rob's.
This is just the amendment.
So
here.
this, I don't recognize this as being in what Rob had proposed.
I pulled it from his document.
So,
It's in 12, it's in the 7, the 12, and Rob's.
All right.
so let's hold questions, but what you're basically stating is if we create an independent court and if that amendment requires there to be a hearing for every time there's a termination, you're saying that would obviously clog up their docket.
Yeah, not necessarily court, it could even be internal. So, let me get back in my train of thought.
Thank you.
Okay, my last line is, because this is ambiguous, hang on, my train of thought's completely gone now. Let me back up a second. So if this is read to require a hearing for every termination would need to have, I would assume, an administrative hearing. Like there is the possibility of our appeal process, not necessarily across the street. Due process does not mean going into court. Due process has a larger meaning. It just means someone's had the opportunity to have their version heard by somebody properly empowered to make a decision. So right now we have our appeal process. If you're terminated, you get an appeal. That is a form of due process. When I read this, I can't help but acknowledge that it could be read that every single termination has to have an appeal under the existing appeal process. That would be onerous, obviously. My concern is if that is what this is decided to mean, frankly, if I were management, I just wouldn't term. And to be very blunt, and again, I'm going to be blunt today, there are a lot of managers that just will not terminate because they do not want to go through that appeal process. It is what it is. Management here has dealt with it for a very long time. Right or wrong, it's reality. I do not know if that is the intent here, because I could read it to mean that the current HR policy has, if you're termed, you get an appeal. That may satisfy this section. My ultimate point is it's poorly crafted because I don't know what it means. I can read it two ways, which means some employee gets terminated, something happens, it doesn't go the way they want, they go to court, the court will decide for us what that section means. It's in our interest to take a section like this and craft it more carefully if we're going to require constitutionally due process for employment. And I will say this, if there is going to be a constitutional right of due process for employment, if that's the path we want to go, okay, we will want to do a lot of work internally on how to handle that and what it means. Right now, we are at will, and just because you have the ability to appeal for termination does not mean we're not at will. We're an at-will employer. I have not had the time yet to look at whether or not this type of language eliminates us from being an at-will employee. I will. I'll get there. Just haven't had time yet. If we're not an at-will employee, can't say right to work because that's kind of a union term, but the words fit. If we are going to move away from at will, we'll obviously need to have a lot of implementation time, get the HRs ready, and be prepared to account for that reality. So just from 30,000 feet, when it comes to this section G, I don't know what it means. It can mean a couple different things. We'll need to decide what it means. I do not remember the intent from when this was originally put in. So flag that one. Of everything in here, that's probably one of the more concerning sections I flagged.
Aaron, I'm starting to see hands up. Do you mind pausing, taking some questions right now?
You told me to finish, so it's up to you.
Aaron, you okay with that?
I'm just going to say that the problem with the suggestion that we don't participate is he's admitting there's things that he doesn't either recall or know what the purpose was. And those of us who have been around for years that attended those sessions that know that, what we're doing is we're going to do this review with the absence of that information, or at least, you could say it's my opinion, I guess. And then we get to the end of it, and then it's not going to be meaningful because it's going to be long after he brought the issue up. So it's not going to be meaningful, it's not going to be helpful to provide a list of things later. So I don't see the value of doing it that way. And so I'm trying to decide whether or not I've got any reason to be here in person. I might attend from home and just listen. If that's what we're mandated to do, I'll just listen from home and write up some suggestions from there and very quietly and politely do it that way, not storm out of the room or anything. But I just don't see that this is the very role of a legislature. This is what our job is. The legal advises, and then we make the decision based on what we hear. And if the legislature is not permitted to engage in those discussions to either understand or flesh that out, and then we have to give like a short summary at the end of the day, that's not meaningful. That's forfeiting and abrogating your role as a legislature. If you don't support any change at all, that might be just perfect. But
So Aaron, no one's silencing you. It was just a suggestion to hold questions until the end. If you have them and they're burning and you can't wait until the end, fire away. So let's take a break. Let's take a 5-minute bathroom break. And
I actually want to hear what he said because I don't know the intent.
when we come back, this would be a good stopping point to ask some questions, and we'll just do that a couple times. We won't fire him away. How about a compromise? How about every, I don't know, half hour or something? That way he can make some progress and move on to it, or a page, something like that. But I don't want to have the whole process filibustered either because we have to get through this document. So we have to find a balance. So let's just take a couple-minute break, and then we'll ask questions, okay? Yeah. All right, guys, let's go ahead and get started again. We're back from break. Any board members have any questions for legal right now? Okay, and if you guys have a burning question, put your hand up. You know what I mean? If you guys can wait until the end, wait till the end. If you guys need a refresher and have Aaron scroll up back to the top, we can go over everything again, you know, whatever we need to do. So let's fire everything back up and let's get
Here we
started.
go. I had a quick talk with payment on the side, and it sounds like the original intent of this section was the best, easiest way to phrase it is employee rights litigation. So if you're wrongfully terminated, you have an access in tribal court to challenge that. That's fine too. So however we phrase it, this is framed as this would be an employee rights issue. You've wrongfully terminated. You have the possibility to, in a properly authorized form, challenge that decision. So that makes sense. I got it. On the H, I feel like H would be buried up in G because they feel that they're somewhat related, but there's more to it than that. So H had said, I guess I didn't really mean to cross it out. It's supposed to be underlined. Discharges any person from employment or takes any other retaliation against an employee who makes public any information of misconduct by officials or employees of the tribe. So I can see the intent there. So what I would call this is a whistleblower statute, which the tribe has talked about before. I don't know if I'd necessarily put it in a constitution because, for example, as written, I would have innumerable questions. Constitutionally authorizing me to leak something that is otherwise confidential, from board files that I decide was misconduct by the official or an employee of the tribe is just an incredibly slippery slope. So what I would advise on H, if we're going to call it for ease of conversation, whistleblower, is this is an instance where we need a body of legislation to put some sideboards on it, because it does tie up to G in some regard. If someone is terminated because they leaked information, that's going to be in the eye of the beholder if the employee has protections for leaking that information because there was misconduct of the person who's the subject of it. So H is what H is probably it's a 30-page statute that we would want to put together at some point in the future. So again, not supposed to be crossed out. It ties in the G, and I would consider it part of an employment right. So we need some work to make happen. I, speeding public trial, very basic. J, excessive bail, excessive fines, cruel or unusual interrogation or punishment, fine. K, denies to any person within his jurisdiction equal protection application, opportunity under the law, very basic comments, that's perfectly fine. Next. Just waiting for Lana.
Sorry, there's some technical difficulty. The screen in front of us was all black. I'm just letting the people on Zoom know. So Lana was trying to get it figured out with IT. Seems to be fixed, so that's what the interruption was.
L, directs a criminal proceeding against a specific individual or group. That's all normal and fine. M, denies to any person accused of an offense punishable by getting to the clink the right upon request to a trial, basic and fine. N, I'm not sure about N, denies to any person the access to their own personal information maintained by the tribe. I'm not sure if this is intended to operate as a FOIA. So in a general sense, I can go to enrollment and get my stuff. I can go to HR and get my stuff. But if, like I have, most managers or supervisors have, for example, I have a management file. In that management file, I maintain, notes or comments that where I deal with my employees. So when Josh shows up late 35 days in a row, and I don't want to write him up, I might write a memo to myself and put that in a file I keep. Is that his information or not? I don't know. So I would have some questions, what we're really trying to get at here. And I'll take N as a point to pause and make another comment. So when the original process was set up back in the early 2000s, it was obviously a large community effort. And you can tell by reading the big 2012 document that a lot of the things that are included were things personal to somebody. Something happened, somebody had an experience, and they wanted to make sure that didn't happen to anybody else. So they fought to have it included in the document, which is perfectly fine. This many years later, it's a little bit tricky to look at it and try to, peel back the zoom and say, what's the overarching desire here? So behind N, there's a story. Someone's trying to get at something. And we just need to kind of peel back those layers and what are we really trying to do? Because this small sentence on its own, I'm not sure. Which means it's an ambiguity, which means we end up in court. This is an example of something where we want to tweak it and fine tune it and say exactly what it is we mean. So we're not asking a judge down the road to tell us what it means in their opinion.
Okay, Aaron?
So, again, I'm still trying to decide what I'm going to do. But if it's helpful to just give quick sort of responses to flesh out what we were intending.
If you need to talk, go ahead, yeah. You don't have to give an explanation.
So the one thing that we wanted to protect against is board members who, again, think they're social workers, think they're qualified, calling up and asking for client-based information. If you talk to Christine, she'll give you a big, long list of times that's happened and why it should never happen. Because if you're a board member, you are not qualified to poke your nose into somebody's private confidential information. So that's one thing. We wanted to protect against that. The other thing we wanted is because some people were demanding a copy of their file. And for some reason, like their health file, for some reason, they weren't getting it. And there's no reason why they shouldn't have a copy. I think HIPAA requires you by law to provide a copy of their file. So those were the two things. Somebody made a big argument that they were denied their health file. The other one was to protect tribal members, and it is in our membership code that information is protected, it's confidential, can only be released by a vote of the board, but we did have board members, and we still have board members that are stepping in and asking questions and making staff very uncomfortable to have to give them confidential client-based information.
Got it. Okay, thank you. So this is our Second Amendment. I underlined by the tribe, by law. That's just another example where we have unnecessary language. I'd want to go through an editing process and kind of clean this thing up. So specifically, I said, not sure why, quote, the law is included unless it seeks to capture state or federal law. So if you eliminate by law and simply say use of arms subject to regulation by the tribe, period, I understand what that means. By the tribe pursuant to tribal law, I know what that means. When it says just the law, in our world, because we're a tribe and because there's this weird spider web of when state or federal laws may or may not apply, we tend to be very specific. In here, I don't know if we unintentionally are importing state or federal law. So O is just an instance where we'd want to clean the language up, and the last thing I want is a Second Amendment case, in tribal court. Territory and jurisdiction, Article 2. You'll just see some blue edits to kind of formalize the language. When you say United States, you'd use the full name, United States of America, Treaty of Washington, just some edits. Otherwise, this first territory paragraph I think is good. It captures everything. I don't know if Clarence was here, I would look at him and say I can tell that second and third sentence are from Clarence. When he went through this process, he was very, very passionate about the inclusion of protections for treaty rights. The second paragraph I've underlined to that it's I think the intent is clear. The language is concerning. No territory shall be ceded unless authorized by law, subject to the approval of the voters in a special election. I'm okay with that. I know what seated means in my head. I think everyone else knows what seated means, so I'm not terribly concerned about it. Seed is a pretty specific word. Second part, no real property, tangible property, or intellectual property of the tribe shall be transferred, mortgaged, or otherwise encumbered unless authorized by law. So from 30,000 feet, that's obvious. Of course, that's what we need to do. But there are some concerns on how we make it work. The language is very broad when it comes to tangible and intellectual property, and we would need to come back later and review legislation and potentially create more legislation to make sure that this kind of language doesn't thwart the conduct of our government and business. Because we are so big in the government and the businesses, because we're so large, there are going to be things that are moving out that we just don't think about. And we fired people for it. So for example, with the ARPA dollars, there's all kinds of new furniture coming in. The guys are on third floor the other day taking away a bunch of old furniture, a bunch of old office chairs. And I'd walk by and I just commented, I need 2 chairs for a deer blind. And I was like, that's perfect. And he's like, take it, it's going to the dumpster. But I didn't, because I remember years ago, we fired somebody for taking some plastic Coca-Cola glasses that were going to go in the dumpster. And there are some policies that govern how we give away things. So because we're so big, that kind of language just gives me a little bit of pause. I'm not opposed to it. We just need to be careful and not accidentally go too far. Because of our size, there are things that are just, hey, this is going to the dumpster, take it home. And no one cares. We have fired for it. So it's one of those little tiny things that you don't think about. It just we need careful thought on it and make sure we're not unintentionally causing a problem where maybe there isn't one. Maybe it's just a policy clarification, but it's just on my list of examples of let's be careful.
Aaron?
Just real quickly, it seems like we don't want to muck up the ability of the tribe to do business.
Correct.
So fee simple property is something different. And I think that seated might focus or should focus on trust land. We have had staff who have waived sovereign immunity without permission and led to multi-million-dollar losses in litigation. So we want to make that clear. And I think that not everything, and I think you said this before, has to be in a draft in a constitution, but could be legislatively addressed. So theft from the tribe that's not reservation property could be treated differently than reservation property and trust.
And if I could add to that as well, so like a lot of the content in this could just be inserted into HR policy, like the stuff about getting a hearing if you're terminated. I mean, what's that doing in a constitution? You know what I mean? So a lot of this stuff isn't needed. I'm sorry.
Section 2, jurisdiction. The jurisdiction, so I eliminated, this is another example where we have words we don't need. The jurisdiction of the tribe shall extend to all persons, properties, and activities within the territory and shall include the treaty right, perfectly fine. Second sentence, the tribe shall have the power to assert the sovereignty and jurisdiction of the tribe over all matters that affect the interests of the tribe. Nothing in this article shall be construed to limit the ability of the tribe to exercise its jurisdiction based upon law or its sovereignty. It's slightly duplicitous because that language is found elsewhere. So that's just a note to me to make sure we go back. And that type of language is only used once and not twice. That's more of a note to me than you guys. Article 5, separation of powers. This is the big one. Branches of government. There shall be one executive branch, there shall be one legislative branch, one executive branch, and one judicial branch. I want to pause for a quick second and just put a point on throughout the remainder of this document, the branches tend to be referred to in different ways, which is concerning. So as there's going to be a detailed editing process, well, I would like to stick with there's a legislative branch, there's an executive branch, and there's a judicial branch, and not use different terms. Just a minor editing tweak. There shall be a system of separation of powers and checks and balances between the branches of government. No branch of government or official of any branch of government shall exercise any power granted in this Constitution or properly delegated by law to any other branch of government except as expressly directed or permitted by this Constitution. And each branch shall act as a check and balance upon the actions of the branches as permitted by this Constitution. So you saw me just highlight a couple of purple things in purple. Overall, this is the big section. It's written well, except for I just flagged two things in purple, and I'll tell you why. Before we send anything out, I am going to ask for the opportunity to share our final proposed documents with a number of other attorneys. I want more eyeballs on this besides me, Josh, and poor Ryan's getting ready for court, so he's booked. But when he gets out of that, he'll dive into this with me. I want more eyeballs. Here's an example. I've read this section a couple of times, and it just popped out me. No branch of government or official of any branch of government shall exercise any power granted in this Constitution or properly delegated. I want to have a conversation with a bunch of law nerds. Is using the term properly delegated a good idea or not? Or should I just say delegated? Is there a legal distinction between properly delegated and delegated? I know it's nerdy, but those kinds of things matter. So I've just flagged it now, and then just below it, expressly directed or permitted by this Constitution. Similar. Is that phrasing okay? Or do you set yourself up for, in the future, under litigation, for the court to have an opinion on properly, improperly, expressly by legislation? It's those kind of nerdy drafting notes where I want to make sure we're getting it right. Otherwise, section's fine.
Okay, Aaron?
So that's a good catch, because I think that's probably the problem that some of the other tribes have faced with interpreting what is the authority and not the authority.
It's the core of it.
Even using the term delegated suggests that there is no inherent authority unless it's delegated. And that's where we are right now. While some board members will make the argument that, oh no, that's already the chairman's authority. It's the assumed or understood authority of the chair. Well, that's all fine and dandy until you do something and then they don't like what you did and then they come after you. So we have no delegated authority to the chair right now. There's this presumption there's some kind of inherent authority of the chair, but that's complete nonsense. That doesn't exist anywhere. So I think we got to tighten up that language even more tight than properly delegated or even delegated, because if it's not so defined in the Constitution, then what right does the legislature have to delegate or not delegate the powers of the executive branch?
Yeah. This section, this paragraph, for future conflict purposes, this is probably the most important paragraph in the whole document, because it is the nut and bolt of setting up the three. So Aaron's right. This one has to be right word by word, period by where the comma is. Shockingly matters. You wouldn't believe how much litigation there is over commas, because people read commas differently. There's the Oxford comma. There's a pregnant comma. It matters. I would want to send this to some constitutional attorneys that specialize in these things, get their opinion. The constitutional litigators. This one needs to be right. This is a very good start. This is not a bad paragraph at all. It just needs some little fine tweaking and more eyeballs. Next article is judicial branch, which is a big one because it's recrafting the entirety of what happens across the road. Before I even start, this I'll reiterate what I said on the paragraph above. I would want some more legal eyeballs on this. I would want some folks who are very experienced in judicial systems to have an eyeball on this to make sure everything's on the up and up and everything's good and we haven't made a mistake. I don't see any massive mistakes. We just, again, need to be careful. So we're going to spend a little bit of time on this judicial branch because in all intents and purposes, what this does is we are setting up a body that is equal in power to this board, and we need to be careful in our words and careful in our intent. There shall be one judicial branch, shall be made up of a trial court and a Supreme Court. I would eliminate this Court of Appeals because it just doesn't need to be there. I'm going to take a pause. It's not the same thing. So words, the words need to matter. We have a trial court and we have a Supreme Court, full stop. There is no need to say Court of Appeals. Doesn't exist anymore. We're changing the name. A judicial commission, which will be needed. An appropriate staff as established by law. I've underlined that. The judicial branch shall also include trial level courts of special jurisdiction as established by law. So my underlining, I don't see a reason to place support staff in the Constitution. Of obviously, they can have staff. It doesn't hurt to have it in there, but as an attorney, I'm very wary of language that just doesn't need to be there because you can never, ever anticipate how that causes you a problem down the line. That almost comes from just experience in contract law. If the sentence or the clause doesn't do anything, doesn't add anything, you might just want to take it out. So obviously, it's prudent that a court can organize its staff as it sees fit for the continuity of business in the court, and importantly, allow it to move how that staff is structured if something isn't working. The last sentence I address in blue. The judicial branch shall also include trial level courts of special jurisdiction as established by law. It functions, it works fine. I would want to shrink it because there's a lot of words. A better sentence would possibly be the judicial branch is empowered to establish courts of special jurisdiction. So you take a sentence this long, you shrink it down to this long, it gives you the same thing, less words. And I will admit that over the last 20 years, there has been a significant move within legal training for lawyers to be much less wordy. It's called plain language. It's taught in school now. I was taught to be wordy, which is why sometimes my emails are so long. I'm trying not to be wordy. I'm trying to be short and sweet and concise. So because this was done 20 years ago when we were expected to have long, detailed sentences, we're now told don't do that. It leads to litigation. It leads to problem. Shorten things down. So this is an example of what I've written in blue. It looks like a human being wrote it just speaking English. The first way, it's a lawyer. There's extra words because that's what lawyers tend to do. It's an example of a new style of careful crafting. A, composition of the trial court. Trial court shall be made up of one chief judge, perfectly fine. Any other associate judges or substitute judges as authorized by law. I want to make sure I come back to that point. That's fine. Chief judge is in charge of the court, et cetera, et cetera. I flagged something here. An administration of all trial level courts, including, comma, subject to the laws of the tribe, comma, the employment and discharge of court personnel. There's a couple places in this document where straight out human resource related issues are included. They're just inherent in that position within the structure. I would want to take those out. Their inclusion doesn't hurt anything, but they just don't need to be there. They exist anyway. If there needs to be tweaking, we would do it in legislation. So, let me give you an example. So I'm the general counsel of the tribe. I have staff in my office. Obviously, I'm in charge of the staff in my office. Doesn't need to be in law that I am. It becomes a human resources issue, becomes policy/procedure. there are going to be instances where some law needs to kind of hammer that down. We would do that in legislation. So this type of language just has no place in the Constitution. Out of the gate, it belongs in policy procedure. And at the extreme, if we have to do something, I would put it in legislation so we could amend if something isn't working. B, composition of the Supreme Court, which is what now we call a Court of Appeals. The terms changed to Supreme Court. This is looking at 5 justices on the Supreme Court. There'll be a Chief Justice, 4 associates, and additional alternatives established by law. That means legislation. Chief Justice will have oversight authority of all matters relating to the operations and administration of the Supreme Court. It's similar to the above. I don't know if I want that in the Constitution for the reasons I just talked about in A above. The reality of how the court operates now, and I don't know if that will carry on. We may want to let the court settle into its own groove and let them figure out who's in charge of administration day to day and let it be handled in legislation. The reason I bring it up, the way it works now over there is we have a trial judge, we have a court of appeals, we have all that staff, and we have the magistrate. The magistrate, for all intents and purposes, runs the court staff day to day. They're the boss of all the staff. They're the ones making sure the paper flows back and forth. I don't know if it's in anyone's interest that we make the Supreme Court or the Chief Justice of the Supreme Court be in charge of whatever court staff there may be. The court staff may have 2 people in charge of them, the way this is written. They may have the trial judge in charge of them, and they may have the Chief Justice in charge of them. It unintentionally may set up an unnecessary conflict. So all of that can be left to HR type policies, and if legislation is needed, we'll do it. Putting it in here just isn't necessary, and it binds us to something that just may not work.
Okay, Aaron.
On the number of justices in the appellate or the Supreme Court,
The 5?
yeah, I don't think it needs to be 5. I think 3, because you just have to have a tiebreaker. And on the Judicial Commission, I'm worried because there was back and forth about having cultural advisors on that commission. I think you can get cultural advice without having them on the commission. And I also think that this assumption that because they're legally trained that they're not cultural is diminishing and insulting. And then the reason why they built into the draft the composition of the court, at least minimally, is because they wanted to get around if the legislature starts playing games with the court and the court's not ruling in the favor of the legislature, that they just basically defund the court. And there is a provision for automatically funding if there's a games are being played.
Yeah.
That's already contemplated. But I think minimally the court should be staffed by in the Constitution so the legislature can't play games with not funding, especially if they make a decision that's not what the if it's adversarial to the legislature, that they decided to defund the court.
Let's see. So section 2, election and selection of who sits on the bench. The boards, you've actually talked about this a few times already, and everyone knows the issue, but we'll go through it. Election of justices and judges, that's a lot, it's hard to say. Justices and judges, except the substitutes, shall be elected directly by the voters. I have a note to myself, it's worded funny, I might want to play with it. Throughout this Constitution, how you refer to elections, you want to have commonality in terminology. So further down, when there's a discussion of electing the legislative body or electing the chair, how the terms are used need to be the same with the judges. All 3 need to have the same terminology. I haven't got to that specific part yet, so I just flag it here. You don't want to say the same thing different ways. You want to say the same thing the same way. So just nerd stuff. B, appointed justices and judges. And so I'll note in the resolution and supporting documents that were submitted by Rob some time ago, he had indicated in another document, you flagged it, that he had added some language where we knew there was going to be a problem. This touches on that area. Appointed justices and judges. In the event that a qualified Sioux Tribe attorney, that'll get reworded. In the event that a member of the tribe who is a licensed attorney in good standing does not register for election, the board shall appoint a qualified attorney under the government charter prices subject to Native American preference. The appointment shall serve. So that section I'll want to rewrite. Rob had told me to be nice, so I'm being nice. That section I'll want to rewrite. So a suggested change is where no qualified member seeks to fill a position, the position shall be filled by appointment pursuant to a law promulgated for that purpose. Note, this requires changes to 10. And see, listen to me. I hereby advise that we plan on finally developing an appointment code. Who talks like that? I hereby advise. That's me. So the reason I point out maybe the need for an appointment code is every time, not every time, oftentimes when it comes to appointing positions, this board and other boards in the past have struggled. It's usually for the big ticket items, whether it be elections or an empty board seat. We all can remember us trying to navigate that. Because this court will have immense power equal to the legislative body, I'm anticipating that there could be a problem there as well. If you recall, we had a board seat that sat vacant for, I can't remember how long it was. It was a long time. Yeah, because the board just couldn't get over the hump and get the process to work. That's not good for the legislative body, and it's not good for the judicial body. So what I'm suggesting here is we legislate something that just, here's the roadmap and how we're going to do it. In essence, force you to make a selection whether you want to or not. I'm lying. I do have some ideas of how it could work, but not today. But just some legislated step-by-step process, timelines, mechanisms. Here's how you're going to do it, so we do it. Having an empty chair for 2 years at the court is just not something we want to allow. So that section, I have some suggested language, but more importantly behind it is how we actually go about doing it, because it could be hard. And this is one spot where we want to put a lot of thought ahead of time into something so that if and when the day comes, we have a codified system in place that will do all it can to eliminate political tendencies, those tendencies being what they are. I'm being polite. So note that one. I don't think this code I mentioned, I don't think it'll be terribly tricky to put together. C and D. These are both areas where I think we probably want to rely on legislation. Upon recusal of the chief judge and all associate judges, the chief judge shall select a substitute judge, subject to restrictions imposed by the rules of court or by law. This and the next selection of substitute judges, these might be things you just want to put in the code we have that will govern how the court conducts its business. It's not that it can't be in the Constitution, but going back to my earlier statement that if you have something that just doesn't need to be there and you can do it in legislation, you need to think about it for a couple of reasons. Number one, if it's not working and you want to tweak the process, legislation allows you to tweak the process. This isn't real high on my list. It may be perfectly okay there. Maybe it's me being a little bit nervous because this is new and could have impacts. So it's just something I'm flagging perhaps to myself to some extent.
Aaron?
So if the legislature fails to do their duty, then they should forfeit the authority on that particular appointment to the executive branch. And I think if you have that as a remedy, they're more likely to not fail to do their duty.
Another way to think of C&D, you guys, so every lawyer has in their office somewhere, there's a big book, Michigan court rules. And when those book, there's all these rules that's how courts do their business. Here, we follow the court rules, and we also have legislation that govern these things. Maybe the better way to do it is courts across the nation have a practice of conducting themselves under their rules or by applicable law. It's been around since day one. It works. I'm suggesting we stick with what works. We'll get back to it. Terms, I don't think there was anything major in terms. The term of office for each judge on the trial court or any other court that gets set up below that, drug court, whatever the case may be. Maybe they set up a probate court, I don't know. 4 years. There has been some discussion at the board recently whether 4 was the appropriate number. I can't remember how it came up. Somebody had mentioned 6. It's worth discussing that point. If in order to run for this, somebody has to move to the area, move their family, do all those things, you might want to give them more than 4. 4 years is fairly short for a court term. You tend to want to give them a little more time so they have that built-in protection. Whether it be 6, 7, 5, 8, 9, whatever.
Yeah, it was intended to be more than 4, so it would transcend any chairperson's term.
That's kind of how they're staggered away from the legislature on purpose. So this, I'll flag it right here. Something to talk about. Unless removed, each judge shall remain seated until the oath is given to the next one. Perfectly fine. The terms of office for each justice on the Supreme Court shall be 6. That 6 is fine. And then, unless removed, they stay seated. I don't know why I put a question mark there. It's gone. Terms shall be staggered. Perfectly fine. Section 4, qualifications. This gets up to the election versus appointment problem. Judges and justices shall be attorneys. I've added this license and a state and in good standing. Those are important words. And members of the tribe. I've underlined the following. In the event not register, the board shall appoint an otherwise qualified attorney. And you recall we have different appointment language up above. So I might want to move this section physically in the document, but as it is, just in general, it works. If Josh doesn't put his name in the hat to run, you need a body, it comes over to the legislature, you appoint. Frankly, it's really the only option if we're going to have elected judges and require the membership and the licensed attorney, et cetera, et cetera. You have to have that appointment safety net in there because it's frankly probably going to be necessary. B is needed. A judge or justice cannot serve in an elective office or an appointed position of any other governmental entity. It goes without saying. That one's obvious but important. I'm going to take a break here. Section 5, not a break, side comment. Section 5, I'm going to scroll down. You're going to see a lot of stuff underlined and pages that said legislation, legislation, legislation. So I do not know why. Let me rephrase that. Most tribes, most governments, and Sioux Tribe have a piece of legislation that governs the conduct of the court. We do. Had it for a long time. It works very well. Really, I don't think I've ever heard a problem with it. I don't know, that just does not belong in the Constitution. You want that in legislation for the 2 reasons. 1, it just doesn't need to be in the Constitution. It just doesn't belong there. But more importantly, 3, if it doesn't work, if when it meets reality, there's a problem, we're able to change it. You are putting a lot of faith in the language in a constitution for a whole new court system that we got it perfectly right the first time. The odds of that happening are the same as the odds of the Lions not going for it on 4th and 1. It's gonna be an issue. So I I put this pretty high on my list. And because it's all pretty heavy court stuff, I really don't think we need to go through it. It's all how the court functions. It's the core of their power. It's not verbatim with our existing authorizations, but they accomplish the same thing, save the existing court section would need to have some modifications to account for the new power granted in the court. So rather than go through this line by line, I just want to put a pin in that one. I'm suggesting legislation, and we'll have to come back and talk about that in detail at a different time, because it's a long list of how the court conducts its business. There are a few things I want to flag. They're not terribly important, and we'll talk about them again another day, but just to flag it. Under Section 6, powers and duties of the courts, healing, pretty common for something like this. The primary duty of the judicial branch shall be to promote community and individual hearing and forgiveness in all matters which come before the court in accordance with laws, customs, and traditions of the tribe. Actually, Josh had flagged this. I'm glad he did. This is one where you need to be careful and think about the language. You read it, you just, in your head, you're like, yep, that's what tribal courts do. That's the goal. We want to bring our traditional beliefs into the court and make sure they have a role. The concern is how crafted it opens the door to arguments at sentencing, or allows for just outside litigation that doesn't accept punishment that is common in Western jurisprudence, such as probation or jail. So the way it's written, it potentially could be read to frown upon jailing someone, frown upon tether, frown upon things that are not historically accurate or cultural. So it does say in accordance with laws. So we just need to be sure that we have very clear language in the codes behind this Constitution that those kind of common punishments are acceptable, they're perfectly fine, and then leave it to the court to decide how to apply customs and traditions of the tribe. There's two categories there. There's the Western jurisprudence category, going to jail, and then there's the traditions of the tribe, which is a separate category. And the two can coexist perfectly fine. They do in all tribal courts for the most part. We just want a little thought to make sure we're not unintentionally opening the door. Josh does something wrong. Aren't you glad you sat up here? Josh gets thrown in jail for a couple of days. He comes back and says, a jail is not traditional and customary. You can't do that to me. We want to make sure that kind of stuff, we're not dealing with it.
Cultural customs stuff.
Well, yeah, I had that sentence, but I deleted it.
I'll say it.
Yeah, so Aaron raises a good point. There is always going to be some concerns of what were our traditions or customs, and that's for the court to decide. Basically, so for example, my mother-in-law is almost fluent. She learned from somebody up by Grand Portage. This person over here is almost fluent. They learned from somebody in Manitoulin. They have different approaches and different beliefs on certain things. You can't really legislate from that. That's just for the court to plow through. Trial court on down. All things I'd want to put in legislation, and it keeps going. I'll stop right here at Judicial Commission. So if I take Section 7 and scroll up, almost all of it I would suggest we put in legislation, and what we would need to just be careful with is just under Section 1, composition and power. So sprinkled through everything underlined, there are some things you do want to say in your Constitution. The trial court shall have a real jurisdiction in all cases and controversies, and importantly, on the Constitution, treaties, laws, that kind of section right here, I'd want that in the Constitution. That's we need to state the power of the court. How it's done here, it's kind of dropped through in different areas. You want to coalesce that into a solid paragraph at the top, then all the day-to-day grinder can be in legislation. I wanted to stay, where did I stop? Section 8? Where'd it go? Powers of the court, section 7 we covered. Why am I glitching? Oh, there it is. Judicial Commission. This is a good idea. If the court is going to have its freestanding power, we need some way for them to regulate themselves, some manner. This proposed fix has a Judicial Commission. Similar, a lot of this could be left to enabling legislation. So what you'd want to do under Judicial Commission is we establish them. We tell them what they consist of. So this one has 5 seats filled by members of the tribe, 3 of whom shall be elected upon public nomination by the chair. 2 shall be selected upon nomination of the Chief Justice. All nominations subject to confirmation by the board, 4-year staggered terms. I'll flag something here. It might be a conflict to have the Chief Justice picking people that may in some sense sit in judgment of them. That might be worth thinking about. Maybe that should be this body, maybe it should be someone else. I haven't really thought it through. It jumped off the page at me that I picked my buddy to be on the Judicial Commission. Powers.
Hold on one second, Aaron.
The check and balance is the fact that the legislature has to ratify the nominations.
True.
So the other thing, and I'll say it again, is that this is where a lot of, again, and I don't mean to be disrespectful to authentic cultural values, but a lot of people were trying to get this, they wanted to have a culture court or something like that. And that the problem with that is that we have a diversity of beliefs in our tribes. Not everybody believes, what they read somewhere down the road of the way another tribe is doing it. And so the Judicial Commission has to be people that, I think where it ended up was that they have to be qualified. They have to be legally qualified, that we're not just putting people on there. And as far as our customs and our culture, having them reach out and hear from people as witnesses, I think is acceptable and good. And I think what we did, I think this is around the time that we adopted Michigan court rule, or we were clear about that more clearly when it was drafted, because that's how we do it now. And so, right, and court procedure and requiring court procedure to be non-arbitrary.
So I want to note one thing. This doesn't require these people to be attorneys. That gives me a bit of a concern that we have non-attorneys sitting in judgment over legal matters. It doesn't have to be all lawyers, but you're going to want a lawyer or 2 on there, because the kinds of things a Judicial Commission gets down to are the nitty-gritty, potentially ethics of attorney judges. And that deals with law licenses, and that is, this would be like going to the dentist because your knee hurts in some regard. They don't all have to be lawyers, but you will want attorney or 2 on this body. C really sums it up. The Judicial Commission shall have the power to adopt rules of court governing the branch subject to the laws of the tribe. Okay? So I'll just be very blunt. I don't want to offend anybody, but non-attorneys do not have the ability to competently author court rules. I couldn't do that. That's why in the current system, our code adopts the federal rules of civil procedure, although our court has for years kind of pretended that wasn't there, and they just operate under the Michigan court rules for the simple reason that the great number of practitioners that work in our court are just the local attorneys that work under state court rules. It makes sense. So if we're telling this body that you need to draft them, at the end of the day, they're just going to take Michigan or federal and copy them and say, here, we did this work. So, but if you actually want them to be drafted, you have to have lawyers. There's no way around that. I would have absolutely no idea how to draft those, miles over my head. So it's just something to flag. The commission's needs a little tweaks around the edges. They would want some legislation to maybe enact their powers and give them some sidebars, but doable.
So Aaron, I want to take a break to give everyone a lunch, but on that last topic, I completely agree with you, and that's something that I've been hammering home, from the very beginning of having this conversation. If we're going to have a check on the board of directors, it needs to be a professional check that has a law license. So, our courts can do some things, but having the ability to terminate someone's parental rights is the biggest. It's a life sentence, and if you terminate the rights of my kids, if you do it incorrectly, I'm coming for your law license. Period. So, back in the 70s and 80s when, the tribe was newly recognized, you probably didn't have a lot of members that had that law school education. But right now with rolls open, you probably have about 60,000 tribal members. And there's plenty of them that have law degrees. And if there's some that want to serve on this commission, then they can just go to law school. Plain and simple, have some skin in the game. So with that said, let's take a break and we'll get back together at 1 o'clock.
Yep. All right, getting back into it. Josh mentioned something just a minute ago, and he caught it, and I want to give him credit for it because it's a pretty damn important catch. He caught that nowhere in this draft constitution do we properly convey standing on tribal citizens to bring suit in court. It's almost an assumption. The U.S. Constitution has a standing clause that addresses this issue, so it is a huge hole, but it's an easy hole to fix. So we'll have language prepared that properly conveys standing on tribal citizens, and then notably does not convey standing on non-citizens. Leaving it open interpretation might be a bit of a problem. So kudos to Josh. It was a good catch. I will no longer use him as examples of going to jail today. We are on Judicial Commission. So we talked about general powers of the Judicial Commission. Talked about rules of court, easy enough, although the reality is they're going to adopt either the state or federal and probably make tweaks from there if they so choose.
Hey, Aaron, if you don't mind pausing, let's go ahead and get the screen share up so we can see the red line.
I can do it. I'm going to do it. I've done it before. I told you I could do it.
Is it Zoom? Yeah, good job.
Freaking mean. All right. These specific powers to regulate the conduct of judges, justices, attorneys, advocates, and officers of the court. The commission shall have the power to establish rules of ethics for the branch, to hear any complaints regarding the conduct of licensed attorneys or officers practicing in front of the court. That's all good and perfectly fine. Judicial Commission shall have the power, after providing due process, to make recommendations to the Supreme Court to conduct a disciplinary or removal hearing. That might want some legislation tacked on the end of it. I wanted to talk to some other attorneys about how this would play out. I want to make sure we're talking about conduct of attorneys in front of the court, not conduct of attorneys here practicing day-to-day with you. That's not what it does, but I want to make sure we're all on the same page with this. So we probably will have a couple of edits to clear this up, and there might have to be some enabling legislation. We'll deal with it. Section 9, judges and justices shall be paid a reasonable compensation by the law. I just say it doesn't really fit right there, but otherwise it's fine. Legislative branch. This is obviously another big ticket item. Out of the gate, the council legislature, I really am not in favor that this body be called council/legislature. I personally find that odd. I would ask the board to, when the time comes, we just pick a name, whether it be tribal council, board, whatever. But the slash is odd. So down the road, we'll pick something. It's set at 12 members. And see, here it's called tribal council. Up there, it's called council legislature. So for today, I'm gonna call it the board. The board will consist of 12 members elected by the terms in existence at the time. So this attempt is when this goes live, everybody's in a seat, everybody has a term. The goal is to leave that in place until the next election. So that's clear enough. I might think a different way to handle it. I might think of a different way to word it. I'll come back with something on that. Not terribly concerned about it because obviously that's what we're going to do. Terms, election cycles, and tribal codes that govern the elections of the council or the board that are consistent with this constitution shall remain enacted unless legally changed by law under the authority of this constitution. So that's a choppy sentence, which is one reason it's underlined. Terms, election cycles, and tribal codes that govern the elections of the board that are consistent with this constitution shall remain enacted unless, well, you don't say, it's unless changed by law under the authority of this constitution. So that sentence is going to be rewritten. It's probably going to be a bit longer. It's clear what the intent here is. The intent, if I'm reading between the lines, is to, for all intents and purposes, take Chapter 10 as it stands and don't touch it. You're in your seats, you have your terms, elections are staying the same, heading on out, unless there's some litigation and the court finds something's wrong between the existing Chapter 10 and this proposed constitution, it'll be changed. So that, this whole subpart A will probably be tweaked a bit, just to make sure it's very, very clear what we're doing, and it's not ambiguous. Section 2 powers. There is a significant problem with this section. It might be one of the worst sections in this proposed draft. Legislative powers shall be vested in the board as follows. A, shall have the power to make laws, raise revenue, borrow money, enact a budget for the entire tribe by law, and any other action that's provided in this Constitution. The legislature should not have the power to enact a private bill. So this is in bold. This is concerningly short as compared to board powers that are deleted in favor of this section. Normally, this does not authorize the board to hire counsel. Put a pause right there. So the current Constitution, the board powers are A through, no, hang on. So A through N. Powers are listed out from day one. They're clear, they're concise. We know what they mean. This takes a significant amount of language and deletes it in favor of a paragraph. This will, without doubt, cause longstanding, significant, damaging litigation. This section cannot stand as it is. It just cannot stand. If there are problems with how the powers are currently listed, that is perfectly fine and tweaks can be made. But to boil that power down to just a few lines is just a disaster in the making. This is very, very, very high on my list of things we most certainly have to fix. Second, you'll see something in green. The board shall not have the power to enact a private bill. A private bill, it's a tricky word. It deals with a lot of laws that have to do with in between individuals, property, tort, agency, family, employment, corporate law. This prohibits us from adopting laws in those areas, and I don't know why we would. We would want those laws. We have a lot of those laws, so I'm assuming this was the drafters perhaps not using the right word. So I'd want to go back to those that were there and just get a sense of what it was they were getting after and maybe tweak that language a little bit. I want to go back up to my bold and yellow when I had mentioned that there was a concern that the board's powers have gone from a page and a half to a few words in a sentence. And I frankly might want to save that conversation until there's more people in the room because it's kind of one of the big ticket items, but we'll go. Bold language. This is concerningly short as compared to board powers as they exist now. Notably, this does not authorize the board to hire counsel. When there is a separation of powers, you need to have two legal departments, one for the chair's office and one for the board. This is because of ethic issues, because each can litigate against the other, they need to have their own legal representation. So as it stands, the board would be its own branch of government, but would not have the ability to hire legal representation. I assume that was an oversight, how this is put together. And if we are to reinstate the board powers as they're currently drafted, or something very similar to, of course, it would have that language. So the concern under powers is the board powers have gone from a page and a half down to a couple of words in the sentence and are lacking a significant number of very important clauses. So put a big pin in that one. B is the annual budget. So the budget process under this proposed document. It's a little bit different than what we have now. It's more formalized. It's more on paper telling us what to do. Annual budget shall include all revenue and funds controlled by the tribe and all revenue and funds received by the tribe from any and all sources. The board shall have the power to conduct one quarterly budget assessment. If you're into the budget world, you might want to underline that part. One quarterly budget assessment. As things stand, we tend to come in and modify budgets simply as needed. That would have to be a little more organized now. And make appropriate modifications to the annual budget by law. I'm assuming that means by resolutions. I don't think that means that you legislate a new law that tells you how to change your annual budget. Upon request of the chair, this is an instance where we use OGM, we use chair, the boards bounce around. Upon request of the chair, the board shall have the power to make the requested modification to the annual budget at any time. That somewhat conflicts with the above language, but it's fixable. No money shall be drawn from the treasury unless it has been separately and previously authorized by law and included in an approved budget. I do want to put a little thought into how that is worded. No money shall be drawn from the treasury unless it has been separately and previously. So I don't know what those two words are meaning, separately and previously authorized by law and included in an approved budget. So as things stand now, the budget is approved by resolution. So authorized by law, in my mind, tells me a budget is voted on, approved here, and that's the law referring to. I don't think it's referring to a statutory law. The separately and previously, I might want to play with. Separate from what? I don't know what that word's trying to do, unless it means some kind of line item. And previously, so there's that whole section, that the sentence, no money shall be drawn from. That whole sentence just needs to be kicked around a little bit. And maybe stated more clearly, so you know exactly what it is it's trying to convey. I think I get the sense of it. What it's saying is, you only get to spend money if it's been properly approved. You know, that's fine. You just got to play with the language a little bit.
Okay, Aaron's got something he wants to say.
Yeah, so the reason it was put in there, I think the intention was to have an annual appropriations and allow for quarterly cleanups. So I don't think if it says it's only once on a quarterly, I think it was intended to be quarterly, so that is different than what we do now. It would require that we be more organized and we have quarterly amendments ready so that they happen on a quarterly basis. The other reason is previously, or whatever that language, I can't read it because it's purple or pink.
Separately and previously authorized by law.
Yeah, the reason that's in there is because this was right after $2.3 million was expended by the chairperson without having been previously appropriated by the board of directors. Also, when I came into office in 2004, we found that the chairperson was spending hundreds, maybe millions of dollars on what was called tribal ops, like paying for board members, family members to go to college in a fancy fine arts college in California, or paying for certain people to go to hockey school in Grand Rapids without having been previously put in a budget or appropriated. The argument was there was some kind of de facto inherent authority of the chairperson to spend money, which is just total nonsense, because in our Constitution, only the Board of Directors can appropriate funds. And so that was put in there specifically so that there was no question, and maybe it's inarticulate or it needs to be cleaned up, but it's so that the administration cannot spend money that is not in a budget. You know, a couple other examples is whole departments in the casino were spending millions of dollars that were not previously appropriated. So that should not be able to happen. Only the board has the purse strings of the tribe to appropriate funding.
Understood. Yeah, that's kind of what I thought it was trying to say. I'd mentioned earlier that a lot of the language you see in here, you can tell there's an event that drove the language, because the language is so Yeah, it drills right down to something because it's looking at a specific, the language is mad at this little bottle and it talks about that bottle. It gets too specific, which
Except
is a
for they're not
normal
little.
reaction.
The barge was a several $1 million expenditure. Entertainment overspent $1.3 million without any authority, not in a budget. So they're not little things. They were real significant, to me, embezzlement or misappropriations at the minimum.
Okay, understood. Section C, if the board fails to approve a budget by the start of the fiscal year, then those tribes shall continue to function at the level of a previous year's budget. So a continuing language. We talked about that a little bit at the court earlier. Necessary, needed, crystal clear. I do want to take a look at other ways to say it. It looks like it works to me, but I just want to see some other examples to make sure we're not missing anything, or there's something we just don't know on how this is going to operate. But it needs to be in there.
So one thing that is missing is we've gotten a habit probably the last decade of doing continuing resolutions, but the mistake of continuing resolutions, if it doesn't include additional funding for grants, because continuing resolutions approve what was approved last year, and if a grant came in and it requires an additional expenditure, basically we're forfeiting that federal grant if we don't fund it to match the dollars that require if there's a match. So I don't know how to fix that. I mean, we shouldn't be in a position where we can't pass a budget because that's incompetence, but we don't want to risk just a continuing resolution on last year's budget if there is match funding for grants.
Got it. We'll play with something. D, there's some thought to go into everything under D. So D, then little I on down. There's a lot of stuff you'll see. I say legislation, legislation, legislation. A good number of is what we'll call Chapter 14, for just to kind of point your mind in the right direction. So everything contemplated in here is different than how we do it now, which is perfectly fine. That's a policy choice. But I'm going to recommend that, except for a couple of core components, you leave that in legislation. So if something isn't working, we have the option to change it. Let me give you an example. So under Chapter 14, we attempt to recreate Robert's rules and some mechanisms. We stray from others. But for years, we struggled with, there was an improper interpretation of where you used the vote of 7 to undo something previously done. So under Robert's rules, the motion requiring a positive majority to undo something previously done is very limited to something that occurs at the table. So Sean makes a motion to paint the wall green, it gets voted down. Later on that meeting, Mike says, you know what, I'm going to change my vote. He wants to have another motion on painting the wall green. That's a motion on something previously decided under Robert's rules. That requires that heightened vote. At this table, it changed, and it began to be applied contrary to 14 and contrary to Robert's rules, where if something was voted on for the next eternity, it took that hyper vote. That's not how Roberts operates, but it's what we did for a very long time. We always had the opportunity to go back into 14 and clarify it and change it if we want. And this board did make a change to that a while ago. But if that kind of language, if that parliamentary language is in the Constitution and something isn't working, you are stuck with it. It's just a bad idea. You got to be able to amend your rules of the road to fit reality. Even more so when you have something brand new, things are just not going to work. We are going to find things in here that don't work for us. We want to change them. There are some core components you want in the Constitution, so it's crystal clear. But a good majority is put it in legislation. But I do want to run through it so everybody understands it, because there are a few big ticket items. Under DI, each proposed law and budget of the board shall be embodied in a written bill. This document uses the word bill. In your head, just think of the word resolution. It's up to you how you want to label your legislative documents, policy choice. Every board member has the power to introduce a bill or resolution, which shall be read aloud into the public record and placed on a legislative calendar. That's a different way of saying that any of you can write a resolution, submit it, and it goes on an agenda. So those are obviously things that you want to handle with a parliamentary rule, because there's a lot of meat that goes in that grinder. Requires us to place the name of the primary sponsor. These are all things we're familiar with. Shall include an explanation of how the law derives from, comports with, or affects the customs and traditions of the tribe. People might get mad at me a little bit, but I'm not a big fan of that one. If I'm going to introduce a piece of legislation to paint the wall green, you're forcing me to describe how the customs and traditions of the tribe relate to me painting the wall green. It's a forced performance. It has its place, and then there's some places it just doesn't fit. Do with it what you will. I just want to flag it. It doesn't hurt anything, as long as we all know we'll, in some instances, maybe just be kind of giving a canned statement in that instance. Every bill or resolution shall include a statement identifying the specific law, if any, to be amended, superseded, or repealed. Basic. Just about everything in that section I would suggest belongs in legislation, so we're able to amend or bob and weave if necessary. Under 2, the board or a committee of the council legislature, that's not defined, so for now I'm just going to assume they mean our subordinate boards, either the ones listed in chapter 14 or others, shall be required to conduct at least one public hearing in any district. Note that this eliminates the word unit and uses the word district. One public hearing in any district held outside the time of a board session, which shall include time for public comment on a bill prior to passage. So this whole section right here, before you vote on something, it tells you that you need a public hearing in only Unit 3, not 1, 2, 4, 5, because it has the word any right here. So I think that's probably a bit of a typo. So let's focus on that. This section requires a hearing in each unit on everything that we're going to be voting on. I'll let you decide how onerous that is or is not. That's how I read it. That will obviously take a bit of planning to pull off.
Okay, Aaron has a question or comment.
I wish Clarence was here, because he's actually the only one who attended every one of those sessions. But what I recall is that they meant that at least one hearing. And the fact that it says district is because this was before technology. So a lot of public notice and comment is now virtual. And so I don't think it meant, one in each unit or anything like that. I think it means at least one hearing. And I think if we eliminate the term district and just at least one hearing, I don't know if we need to clarify somewhere else that it could be virtual, but it could be de minimis as possible, just to get input if people have it. Like, there's only been 3 people on all day today, tribal members other than board members and staff. So whether we get input or not is a secondary to the right to give input if they want to.
Well, that's fair, but what I want the board to hear is there's a board meeting next Tuesday, and there's resolution number 4. You can't vote on that until you've already had a hearing, in another district. You're adding several weeks before you're able to act on that. And then further down, it talks about 30 days. There's a couple sections that deal with this. It's like it takes our current 5-day notice, and it replaces it with a 30-day window and the need to have another hearing or presentation in a single unit of your choosing. So the point is, it goes from 5 to whatever that day works out to. And we talked about this a little bit last week or week before, maybe. It'll need a lot of work and thought to understand the impact on the governance.
So go ahead, Aaron, and then Kim Gravel.
Yeah, I would say to a great extent, the board currently complies with the notice and comment, but we don't do it necessarily in an open session. We workshop stuff 2 or 3 times before it ever comes to the table. So I think the practice would be, I do think it should be more than 5 days, especially if the item on the agenda is not distinct enough. Because some play games with putting items on the agenda without saying what it is specifically, and then members don't know whether they should get online to, give their input. But I think if we did a week or maybe 2 weeks, I don't think it has to be 30 days. I don't think it's like all of a sudden a bunch of tribal members are going to be civically minded and start attending notice and comment. But I do think it should be their right to do it. And I think what we do now is minimal, the 5-day advance notice, because there is not a hearing in advance of when we're going to vote, not to the public. The board very carefully, and this is a positive comment about the board, very carefully will workshop things 2 or 3 times before it comes to a vote. But we do it behind closed doors.
So another way to think of this first sentence of subsection II is how a lot of states or the U.S. runs their system, whereby legislation gets assigned to a committee. There's various notices. It gets kicked around there until it goes up for a vote. This feels like it's trying to get into that realm, and that's fine. I would suggest some pretty heavy legislation on how that's actually going to function, which means here in this II, you would just have a bare bones, this is what has to happen, and leave out how it happens. Because that's going to take a lot of finessing and probably going to want to change it. The rest of the section, under the small II, there's actually a couple sections that need to be broken out. So that's just the first sentence of needing to conduct public hearings and.
Hey, Aaron, before you move on too far ahead, I want to call on Kim so we don't get moving.
Not all workshops are behind closed doors. So, sad thing is they are during the daytime if a lot of people work. But yeah, this looks pretty cumbersome, that II. When you're reading it the way it's wrote. And I would have attended every meeting of the Constitution Convention, except I was in a car wreck and broke my neck. After I had surgery, I did come back and kept attending them. So every time I hear only one person did, kind of irks me, because I did attend every one until that point.
Okay, go ahead, Aaron.
The next sentence I've highlighted here. The board shall have the power to compel evidence, records, and witnesses by subpoena. That's a very common thing for a legislative body. We will probably have some kind of council rules of some type to tell us how that's going to function. So it's done in an orderly and organized manner, and everybody involved knows what is expected of them. I haven't put much thought into that. I'll have to do some digging to see how that particularly works elsewhere. These next two are just clearly, that's chapter 14. That's legislative parliamentary rules. Members tribe opportunity to address the board in private regarding a personal matter. You guys are all familiar with how these 2 last sentences work. Maybe another way to put it is, if we have things in place legislatively now, whether it be 14 or elsewhere, that work, and I see those things here, my reaction is, well, it's an existing tribal law, it works perfectly fine. I suggest we leave it as it is. But again, as I go through all these sections where I say legislation, all that will boil down into one heavy paragraph that lays out the core constitutional duties without the hows and the whys that belong in a code. Next, III. This ties a little bit up to the top one about having to conduct a hearing in a single unit. The board shall be required to publish every resolution or bill in the newspaper, website, and other places for at least 30 days prior to a vote by council. I'm going to stop there. So that is clearly going to be problematic for us, just given our size and how business has to be conducted. They'll take a lot of debate at this table on how you want to handle this. There is an important carve-out. A budget modification is allowed to proceed, which is good, in case things pop up. But the core concept that everything needs to be published in this manner for 30 days before enactment, I'm not saying we couldn't do it. We could do it. But we require a significant modification of how we do business. When I say how we do business, I'm going to offend a lot of you, because there's two kind of resolutions we tend to get in the tribe and always have. We have straight business. We need to do something. We need to hire a new lobbying firm because our lobbying firm shut down, and there's a bill out there to terminate Sioux Tribe. I don't want to wait 30 days for that. There's those things where we need to conduct business. We need to buy something. We just need to act. We need to hire a new law firm because USA Michigan went sideways. Whatever the case may be, we need to think through the consequences of that 30-day requirement. A couple of weeks ago, Aaron had made some kind of comment that there might be some levels within that these things can wait 30, these things are some kind of emergency, and we need to be able to act. There's probably some way to structure that out so it works. Then there's the other category of resolution that this language probably fixed, and this is the offensive part. Those are the political resolutions. So you're not taking those resolutions that are written, Thursday morning at 10 a.m. and go to the board office for the packet at 11:30, and they're politically charged. So there's, I guess, a positive lining there in that the political resolutions aren't going to run right to a vote because they sit out there for 30 days. So maybe that's good, but then we got to be able to do business. So I get the intent behind it, but we're core 30-day for everything except budget. We're a government. We need to be able to react when bad things happen, and we'll have to think about it.
Aaron, do you mind me saying something on this? So I think that a lot of this was written with the best intention, but I think a lot of what's in here isn't practical, and it wasn't drafted by people who work in government, specifically tribal government. So, I mean, how many times do we have to waive the rules to add something because maybe we missed like a grant deadline or something like that, and we have to hurry up and get something in? And I'm sorry, I'm just going to say it. It seems like a lot of this is to appease people on the internet who's a small group and a loud group. And I don't really care, if they have an issue with me saying that. I don't know if other people have an issue with it. But, having served in government at the highest level of this tribe, I know that a 30-day notice, that's a long time. Think when we have to settle lawsuits, via resolutions or motions, and it just creates a lot of problems. So if we want to extend it beyond 5 days, we can, but I think we have to be pragmatic and look at how this is going to impact operations.
So here's what I would say. We do things in a certain way because we were socialized to do it in that way because of the deficient structure of government that we operate from right now. And that's the case for most tribes across the country. The IRA constitutions or corporate charter constitutions that treat decision-making like a student government club, which every single vote has to be done by the board of directors. If you go back and look at our history, it's really interesting to look at it, and especially like the way they used to number the resolutions, A, B, and C, is we just grew accustomed to approving things in a certain way because that's the way we've always done it. And what that did was that created the expectation that the board of directors has to make every single decision and micromanage every single decision within our tribal nation. So in the real world, what happens is you create laws and you delegate authority, and then you expect government to operate consistent with that authority, and then you make decisions, that you have to make from the bench, or not from the bench, from the legislature. So I don't think 30 days is necessary, and I'm a student of government, so I hold pristine public comment and an opportunity for the people to weigh in on their government, because no decision should be made in the absence of the people. But we have a representative democracy, so we elect people to represent us, but we don't give them a blank check. We don't give them carte blanche authority to not check with the people on decision-making. So this was drafted before the widespread use of social media and the internet. It was to try to model some better semblance of a government structure so that decisions can't be made in absentia of the will of the people. So I think 2 weeks is probably sufficient. But I also think that a lot of the things that we think we have to have our finger on, our thumb on the nation, could be delegated and through legislation. Like, for example, applying for federal grants that don't require travel support, maybe those could be done without, the anal retentive approach that we have now, that everything's got to come in front of the board. Maybe we could delegate that authority if it doesn't require travel support. For those grant requests that do require travel support, maybe we identify what an annual budget for travel support looks like, and then we delegate that to the administration, and then we can apply for federal grants with a match, within that total amount that's budgeted for travel support. And then the catch on that is the check and balance is if the legislature, once known that we're awarded the grant, doesn't want to implement it, they can always reject it. But the way we do it is very anal retentive. Like, we can't even really kind of look at proposals until we get the board's consent. Then we draft it up and get a resolution to apply. Then once we're approved, then we have to draft another resolution to accept it. Then we have to draft another resolution to appropriate the funds. So we're really in the thick of the minutia that I don't think the legislature has to be involved in. And I say that as somebody who served almost as many years in the legislature as I have on the executive branch. So I think if we think differently about what types of decisions have to be made, I think the appropriations cannot be delegated, and nor should they be. But I think a lot of the decisions that we've grown accustomed and socialized to, that the board has to make those minutia decisions, I think that's micromanagement. I don't think it's necessary.
So I just wanted to add one more thing on that. So there's been a big chunk of the board that doesn't want to see any movements when it comes to budgets, specifically budget modifications, and then just further slows it down. Like, if you want to give someone a quarter raise, you have to jump through all those hoops. You have to have budgets involved. You have to do this. You have to do that. And then on top of that, you're going to tack on a 1 month notice to the membership to potentially give someone a quarter raise. I mean, that's crazy. The other thing to keep in mind is we're more than just a government. We're a governing body that has a managing board over businesses. So you can't pull the trigger on business decisions until you advertise what you're going to do to the entire world for a whole month. You know what I mean? That's not efficiency. So we will have to look at this closer, obviously. Aaron?
Just one other comment about the raises. So, I know members are anxiously waiting, but the board's trying to be cautious and deliberative on the adjustments, not raises that people are going to get. But in the past, so I'm not saying right now, so nobody has to take offense to it, but in the past, when we've done these studies and we've shown what the increases would look like, what's directed that more often than not is if board members see their relative or somebody they like or whatever is not going to get the same kind of increase as somebody else, or, then they micromanage that. And that's what's prevented us from, it might be true right now too, but that's in the past, that's what's prevented us from adopting good fiscal annual increase or even merit increase raises or adjustments. Because once we get that information, then we demand to see what individual people are going to get, and then we make decisions based on whether or not my cousin is going to get, or my sister or my brother is going to get a big increase or not get a big increase, and that's really impeded our ability to make decisions. So I think that we should establish the policy and maybe the legislative process for how those happen, and then get the hell out of the way. Because otherwise, it's always going to be a political decision.
Yeah. And then one last thing, not to pile on this issue, but we manage key employees, right? And sometimes you have to terminate them under motions or resolutions. You're going to notice that they could potentially be fired a month in advance. You know what I mean? So it's the most inhumane thing I've ever heard of in my life. So lots of problems with this. Okay.
Downloading files and deleting files.
Oh, yeah. Oh, yeah.
Okay. The next couple of sections are a mix of things. I'm going to hop around a bit. 4, 5, 6, and 7 are, a lot of these are things we find in our current bylaws and 14, which is just the basic conduct of a meeting. A majority of the whole is a quorum, how you convene, the vote count, all the normal stuff we're used to. It's generally what we see in our bylaws now that is then reiterated and enacted in Chapter 14. So way up on top when we started, I had said that the bylaws, it looks like the bylaws were intended to be eliminated. I wasn't sure because there is some similar language built in here. And I've not had the opportunity to go through and compare the existing bylaws to a lot of this existing language and compare and contrast. So I think what I would do with these couple of sections, and we're going to talk about the veto because the veto is in here, is I'll probably have Josh do it, is just go through this section and compare it to the bylaws and note the differences. And what we do is, I think we'd flag those specific differences to you, just so you can see how they operate. It's generally the same thing. It's just said differently in a different place. Neither one's right or wrong. So I'm not going to spend a lot of time on 4, except when we get to 5, we get to talk about the veto, which is new for Sioux Tribe. So all bills enacted by the board shall be presented to the chair for signature or veto. Chair shall have 10 days from presentation of that document to either enact it or to veto it. And if he's going to veto it, the chair has to provide a written explanation what his objections are. If the chair takes no action on the bill, it shall become law. That would be presumably after that 10-day window. If the chair does veto, the board shall have the power to override that veto by a 3/4 vote of the board. So that section, I think, is fairly well written. Nothing jumps out at me. And I don't know, I said legislation here, and what I mean by legislation there is obviously the chair's power to veto needs to be enshrined in the Constitution. But I would strongly suggest some enabling legislation to really kind of hammer out how that works. I assume this is one of those areas where we could have some litigation. So we want everybody to know what their opportunities are, what their obligations are. Beyond that, I don't have anything else to say about veto.
And this is how 3-branch governments are set up on the state level,
Yeah, that's
federal
common.
level. Executives have a veto.
That's common.
The variance in, and it is by legislation, the variance is whether or not it's a whole veto
Or line
or
item?
if they're allowed to do line item vetoes.
This says veto, so it means whole. If you want to do a line item, we'd have to write line item.
It seems to me that if there's a concern in the executive branch upon enacting legislation that it's just not practicable, it's not going to work, but there's elements of it that could be good, that the executive branch should be able to do a line item veto. But the check and balance there is the override. So if 2/3 of the legislature, which is currently, well, it'll be 12 then, and there's some argument online about that, whether the chair still remains a member of the legislature.
I had the
but
same question.
Well, it's black and white, because if the chair is not part of the legislature, the chairman's not on the board. So, that one's pretty clear. That'll leave 12 members, and the question of whether or not we need a tiebreaker on the board. But it would take 9 votes to override a veto of the executive branch. And I think that's good. I don't think that we should have 6 or 7, it would be 7 people that can upend the whole operation of the tribe, on a veto. So it should be a higher threshold.
Well, it's one of those things where if you're honest about separating powers and having a check and balance, this is a check and balance that exists in every state government in this country, the federal government, several tribes in the state. I can list them by name. So it's one of those things. If you believe in it, show me what authority is getting pulled off, and then show me what the check on your authority is. Kim.
Okay, I'm sitting here listening how the Constitution we have was wrote by the state and federal government. Now we're saying let's follow the state and federal government. What happened to the simple majority that was so important to this board last year? Now we're going to go to a higher number? And then if the chair has the right to veto, we're going to wait 10 days before he can make a decision if he's going to veto it. Is that correct?
Correct.
So a resolution could get passed and it may not happen for a month.
Yeah, so somewhere in one of my notes, I think I give an example where we adopt legislation that has immediate effect, ostensibly, with these stories the chairs veto, so we'd have to very much amend. We'd have to very much amend how we do business here. 'Cause
Which ones it would have?
we would have to have a 10-day pause on everything, no matter what it was. It's just, there's no way around it. And that would be new business for us.
Okay, but I'm just saying, I saw how important the simple majority was last year or the year before when it passed, and now we're looking at making it more cumbersome with
Could I speak to that?
three-quarters.
So we're talking about apples and oranges. So if we're talking about different branches of government, different branches have to have checks on others, right? So I would have that veto over you, but then you would have a veto over my veto if enough people agreed. So this is just basic government, how different branches of government interact with one another. Aaron?
Yeah, and I'd also want to make sure that we're not oversimplifying this, because we're not saying that the two-thirds majority would, is it three-quarters? Three-quarters majority would exist in every decision. And the board's vote to make it a simple majority was on decisions of the board, not on an override, a veto override. So let's make that part real clear. Nobody's proposing three-quarters majority to make every decision. So that's one thing. The other thing is not a back and forth, but the Constitution that we have was written in 1934. The template for it was created in 1934. It was done to expropriate the remaining natural resources that tribes had. It was done to streamline the process to steal tribal land, oil of reserves, natural resources. That's why it was done. That's why we have a chair and a board of directors and not a president and a legislature. So when we try to demonize like the white way of governance, we operate under a Dominion colonized white way of governance now. There's no semblance to tradition or Indian ways. The United States government, with the separation of powers, was created because people exited their country of origin, the first wave of immigrants, to come here because they had no due process. They had no rights. People had no land rights. They had no individual rights. Women had no rights. And the Constitution was created to separate the powers so that the people had some authority. That is found in the Iroquois Confederacy Great Law of Peace. So what we're looking at adopting is more like our Indian form of government than what we currently have now. And I'm not saying anybody's making the argument that it's the white way and we shouldn't adopt it, but if we're making the distinction between the existing form of government, what was created to exploit our natural resources and steal what we had remaining from the tribes and make it real easy, to a government of the people with a separation of the powers. To me, it's simple, it's easy to make that decision.
Okay, we can keep going, Aaron.
The next section is clean and obvious. Any law or budget once passed beyond the veto window, it needs to be published to be valid, which is new but perfectly fine. And all laws shall be compiled into a code, which shall be published annually, perfectly fine. The next section, unless otherwise permitted by this Constitution, any action by the council, board, which does not follow the legislative process shall be deemed void and shall not be implemented or enforced by the government, chair, or any official or employee. I call this section gratuitous because it's one of those statement of the obvious. So we would need the court to tell us that something is unconstitutional, that law needs to be struck down. I'm not opposed to it being in there. It's kind of a statement of reality.
Okay, Aaron?
So quickly, I'll try to do these quickly. The reason it's in there is because of the practice of the board taking tribal decisions, holding them at a gaming authority meeting, and voting on items at the gaming authority meeting behind closed doors that don't have to be done publicly. So that's the reason why that's done in there.
The next section we touched on briefly, to make sure everyone's clear. The board shall elect a speaker among its members. So the speaker, so Austin's in that chair right now, that would be the speaker's position. The board shall have the power to create internal rules and procedures for the legislative branch, including the power to establish committees of the council legislature, comprised exclusively of members of the council legislature. The council shall have the power to employ staff, including legislative counsel, that's attorneys, and a sergeant at arms. So there's a lot packed into that paragraph. I may want to play it through a word or two, and we would want some enabling legislation to kind of structure how it works. But in a nutshell, E is the section that retools how this body works. So the tribal chair is akin to the president. This is akin to Congress. The tribal chair is not at that table. The tribal chair is over at their office. This body, this Congress elects a speaker, a leader. They run that chair. They run this meeting. So that is one of the sections where it really drives home the difference between how we operate now and how it operates when you separate the legislative body from the executive body. The language is really pretty fine as it is. Maybe some tweaks and modifications so it flows differently. And when I say tweaks and modifications so that it flows differently, what I'm getting at is you'll see under E, there's some powers granted right here, power, right here, power. And the next section is about power. So you'd want to put all the powers in one section so they're housed together.
Yeah, just real quickly, one of the other Michigan tribes that has a separation of powers has a speaker, and that is how they select a speaker. And another one has a legislative leader. So it's ultimately the same thing. And one of the tribes does not allow their executive, their administrator, their executive, to attend their meetings. And they have conflict, they end up in litigation. The other one invites the executive, because the executive has to present the appropriations, the annual appropriations proposal, and then they invite the executive so that they can speak from the same mouthpiece on different issues, and they can be in tandem, but the executive attends at the pleasure of the legislature. He's not a member or she's not a member, but they are welcome to attend. And in that government, they have a much smoother government than the other one I was talking about.
So some of you, right when we get back from lunch, we started, and I hit on a probably one of the biggest issues in the whole document. So I want to revisit it because I don't think everybody heard it. F talks about the power of the board. G talks about the power of the board. Then up top of this section, there's another clause about the power of the board. So the power of the board is spread over a couple of small sections. What I talked about earlier is the current powers of this board that exists in the current Constitution that all of this language is replacing. A through N are well written. We all know what they mean. They're clear. This draft, in my opinion, does not convey the same amount of power. They're spread out. It's a little bit hard to follow, and I much prefer that the powers be enumerated in one section, A, B, C, D, E, so we can see them, because there are some that, in my opinion, aren't here, and it's maybe a little ambiguous. And as I've been saying all day, if there's one thing we cannot do, and if there's an area we can't do it, it's this, is the power of this body needs to be clear, well-written, and unequivocal. In this current draft, it's not clear, it tends to be gray, and it's found in different sections and is a little bit disjointed. So this is one area where I would very much want to very clearly state, here are the powers of this new body. If you look under F, it's a little mashed together. Example, under F. What?
Your screen share stopped. Everybody else is still on.
Oh yeah, everybody's on mine, it's just a screen share.
That's twice. The board shall have the power to establish executive departments, commissions, boards, offices, and other subordinate entities by law. All those would not be capitalized. All commissions or boards shall be established in the executive branch, so that's the separation. No council member, again, the capitalized undefined, no board member may be elected, appointed, or employed in the judicial branch, in the executive branch, or in an elected office for any other government, and may not accept any position that creates a conflict of interest. The chair or board members who are otherwise qualified may serve as unpaid members of a business board or any gaming enterprise, and so forth and so on. So that F, in my mind, that's A, a couple sentences, B, a couple sentences, C, a couple sentences, each of those broken out into a self-contained, clear statement of what is happening. The way it is right now, it's they're disjointed sentences conveying idea, and is loaded with ambiguities, which is going to cause problems. Just as an example, and there's little pieces of that council legislative power sprinkled throughout that need to be rewritten and consolidated. Moving on to G, more power language. Subject to the right of referendum, the board shall have the power to enact, adopt, authorize, or otherwise approve any cession, diminishment, relinquishment by law, agreement, or any other means, any treaty rights reserved to the tribe. So it's a power that's very specifically looking at the treaty right, perfectly fine. Any agreement prohibiting or abridging the exercise of any reserved treaty right to hunt, fish, perfectly fine. I'd want to clean it up because I'm not sure what the actual intent is, except to, I think I know what the intent is. I've talked to somebody enough about this. The intent is to ensure that the treaty right as it exists is not going to be diminished by any political action without membership input and everything done in daylight. I lived this when I was there. The only thing I want to point out, which could be problematic, is regulating the treaty by a public vote is extremely problematic. If we're going to amend, whether it be our inland fishing regulations or our Great Lakes commercial regulations, whatever it may be, you know, if we want to change the color on a buoy to a bright neon green, we really ought not have to go to a membership vote to do that. It's onerous. It stops our ability to regulate and govern our exercise of the right. That's what this body is for. That's what the Conservation Committee is for. So I think what I would suggest in G, and I think I know who to call to maybe get an idea on how to phrase it, is just kind of a grand statement. The treaty right holds a special place within the tribe, and there are certain things that, you know, cannot be taken away. You cannot sell the treaty right for a new casino in Lansing, just as an example. But we do need to be able to regulate on a day-to-day basis as is needed. A good number of the regulations that come down through the fishery, particularly the fishery, tend to be pretty quick, and we want to be able to respond. It just kind of is what it is. So I would come back with you maybe with a different way to phrase it, to acknowledge those concerns that I'm aware of, and still understand we need to regulate it on a fairly quick basis.
Aaron.
So remember, this was drafted before the referendum vote to ratify the consent decree, the 2007 consent decree.
I
So
blocked all that out.
Yeah. And I insisted until we finally did it, even though board members threatened to make me sign it or fine me. But we did get the support of the membership, and they voted for it, and they overwhelmingly supported it. Some said that they weren't smart enough to understand what they were voting on. But so somehow we got to figure out how our that referenda fits in too, because referenda are final and binding, and any action we take on this amendment doesn't overturn that referenda. But it has to be, so it's really kind of like a level of change. If they're ministerial levels of change, necessary changes or whatever, that's one thing. But like if we're talking about relinquishing our right to gather in the U.S. forest, and that's both in a Forest Service agreement, it's also in the 2007 consent decree as ratified by the people, that should require a change. But if there's a regulation that needs to be changed consistent with the decree and the referendum that we approved, that should be allowed to happen. So,
Yeah, I know what you're talking about. I understand. We'll come up with something. The next two, H and I, are just basic legislative powers, full faith and credit for judicial orders, which is incredibly important. It's used by the court quite often. And the last is, shall the authority establish limits on campaign spending? I is a bit of an outlier. It's just kind of thrown in there as an election campaign spending issue tossed on here. So I would probably point you to chapter 10. A few times today I've said, you can tell that when this was put together, individuals that have very specific concerns they were worried about because it would make it in, which is neither right or wrong. It's just putting it in the right place. So what I get back to on this entire section 2 of the legislative body is the powers are not well enumerated. They're not well organized. It needs a significant work so we know what the powers are, so we don't back ourselves into, unfortunately, asking the court to, hey, fix this for us, and it's going to take 10 years. That's my speech on section 2. Needs work. Section 3, legislative sessions. I view this as legislation from top to bottom. This is chapter 14, really, in a nutshell. This is how you do your business when you're at the table. I read through it twice, and nothing necessarily jumped out at me as really needing that stamp of constitutional approval. That's really up in the power session. You can, in some sense, look at the current bylaws where there's the basic tenets of how you run a meeting, what the basic requirements are. A lot of the items in section 3 touch on that. And I've mentioned we need to go through the work of comparing current bylaws, current powers, to how that reflects in this new language, and just see how those two line up and kind of pick the path you want. It's almost if it ain't broke, don't fix it kind of situation. So we need to go through this and see if it's attempting to fix things we know are broken. And if we are, then we need to highlight it, and then we can talk about it. So I'm going to gloss over that part. The next big ticket item is executive branch. So this is an entirely new animal. We talked about the court. We have a court. We kind of understand what they're doing, and we're going to make tweaks to them. We have a legislative body. We understand what they do. We're going to make tweaks to them. Executive branch, our only history with the executive branch is our Constitution used to have the line CEO in it that we removed. That's really the extent of our experience with the executive branch as far as being its own constitutional section. So a lot of this are fairly new concepts on paper, and we're going to plow through them. Number one, and we touch on this, I think, twice now. The executive branch will need its own legal counsel because they are a separate branch. We need to make sure that the executive branch is empowered to hire counsel. A, the branch shall be comprised of one chair and any department established by law. I probably want to play with that sentence because it is a bit choppy. And just a reminder, I've seen chair, Ogama, and chairperson throughout. At some point, the board will need to make the policy decision of selecting which word they want to use. Completely up to you. I have no opinion. Under B, the body lays out the departments that will be in the executive branch. I don't know why that was placed in. That it seems like it could be legislation or simply eliminate. So we have an executive body now with all of our various departments. And my gut reaction is that they would generally just continue on as they are, and they would work up to this executive. If there's a strong desire to rename them and reorganize them, so be it. I don't know if I have a strong opinion, but I don't know if it needs to be in the Constitution. Setting aside the section on the prosecutor, that of course is different. So the prosecutor has their own section right here under I. I would suggest that be moved out and just given its own section someplace else. they don't work for the executive, they are on their own. They're a constitutionally elected office, like a county sheriff or the Michigan AG, for example. So they're not under the executive, they shouldn't be here. The elected prosecutor under small I is elected by the voters of the tribe for a 4-year term. I would suggest we think on increasing that term to something a bit longer, just based on realities of that job. Chief prosecutor shall be a member of the tribe, an attorney, and I would amend that to say a licensed attorney in good standing, which is fine, and reside within a 50-mile radius of the, I don't know what that means. So they mean the courthouse across the street upon election office. So you got to be a member, you got to be a licensed attorney, and you got to live within 50 miles. To the best of my knowledge, right now, there's 5 of us, 3, and then there's Courtney. Yeah, I think there's 5. So it's a pretty small pool. It's going to be a problem, very similar to what we have with the judges. We're probably end up having a point, and Rob had touched on that previously. If no attorney is available to serve as the chief, then the chair shall nominate an otherwise qualified person to be the chief prosecutor until the next general election, subject to confirmation by council. So that will take a lot of thought. The reality is, if we do this, the chair would be nominating that chief prosecutor. No person shall be eligible to serve as the prosecutor who has been convicted of a felony. That's good, because if you have a felony, odds are you don't have a law license anyway, Josh. The prosecutor shall not be elected, appointed, or employed in the judicial branch, in the legislative branch, or any other government in an elective office. That's all necessary and good. Chair shall be in charge. The chair shall be in charge of the executive branch of government. The chair shall be subject to laws of the tribe. So that's probably supposed to be over here.
Okay, Aaron.
Yeah, so I would say, I think you're right that there's nothing constitutionally necessarily that defines the executive branch, but we have had a delegation of authority, which is basically like a de facto administrative executive branch. So I think those duties were articulated there, at least a skeleton of it could be a starting point. But I also agree that I think some of the people who were on the committee, the convention committee, they didn't trust that the legislature would enact the departments as necessary. But I do think that's ultimately a legislative function. Also, when I became chair, it didn't exist before I was chair, but I created an org chart when the chairman had the authority to do org charts. Up until I was chair, the chairman had the authority to do it until somebody changed it. We did create a functional separation for the tribal court, tribal law enforcement, tribal gaming commission, housing, everything that was established by regulatory or statute. We had a functional separation of powers, and the only role of the chair was ministerial over vacation and leave slips and stuff like that. But right now, we don't have that. Right now, the board of directors is directly over law enforcement, directly over court, directly over the gaming commission, everything. There's no separation, even a functional separation. So I think that there's those key elements that you mentioned that are regulatory by nature that should be enacted in the Constitution. But I think from that point on, it's a matter of appropriations. And I know that there can be games played by the legislature and not funding or abolishing entire departments. But I think that the legislature will get away with that once or twice until the people see, if that happens, we'll see that games being played, and then hopefully those people won't get reelected, because we have to operate as a tribe. We have to, have a separation there. So I don't know that all of it has to be in the Constitution, but I think the regulatory functions that we want to be separate, even from your executive, they have to operate under regulation, should be mentioned in the Constitution, even just broadly.
So on the chief prosecutor section, I would suggest it be its own article. It's a constitutional office. And I would play with the language a bit. The bones are all there. Just shuffle things around a little bit. And and bring it back to you. Is what it is. It's pretty straightforward. Aaron talked about C a little bit. That would just, again, maybe just some wordplay. So it's flows a little differently, but it is what it is on its face. Terms, chairs for 4 years. Section 3, selection. Again, it's kind of an election / bylaw thing. I shouldn't have crossed that out. The chair shall be elected by receiving the highest number of votes cast by eligible voters of the entire tribe. You'll see I underlined entire tribe. Entire tribe's a little bit dangerous because entire tribe is different than registered voters. So that's all it takes is that little play on words and you're in court.
Hey, Aaron, Kim has something she wants to say.
Go ahead, Kim.
Back to C, when you said that, says that on its own, does that mean the chair would have to be in charge of all of the governmental employees?
Yeah, correct. Yeah, so the entirety, well, there's, maybe, I every time I think about this, something else pops in my head. The chair would be in charge of all programs, departments, all entities would flow up to the chair. We have not talked about how the housing authority fits in that, how the gaming authority fits into that. If Dan Doyle is peeled off into his own little EDC silo, how that fits in that, would those answer to the chair or they answer to the body? We haven't got there yet, and it's all for future discussion, but at a minimum, I can tell you on the governmental side, everything would answer to the chair.
So Aaron, it seems like the legislative branch would just be left to legislate, right?
Yep, they'd be Congress.
And the executive branch would execute, and the judicial branch would examine constitutionality.
Yes.
Checks and balances? Okay.
Just like the US or the state, and even the state and the US have other entities that are siloed off on purpose and exist differently. Let's see, terms. Talked about selection. Qualifications, chair has to be a member of the tribe and voting age. That check for use throughout is just a note to myself. Chair shall physically reside in any unit. Again, I'm just using the old terms for ease of conversation. The chair shall reside in any unit for at least 1 year, and we know how to handle that. Immediately prior to an election for chair, and within 30 days of taking oath of office, shall physically reside within a 50-mile radius of the original Sioux Tribe Reservation as recognized in 1972. My comments on this are, I just flagged the unit versus district. Personal preference doesn't matter. The original Sioux Tribe Reservation, I'd rather that would need to be very specifically defined in Chapter 10, so there's no disagreement on what that means. If there's going to be a bubble, we're going to staple a map to the back of the thing so we all know. Yeah, but we want to know. Is it the center of the mission? Is it the southern edge? Because it's big. It's going to matter. So that section alone isn't problematic from a legal standpoint. Just some general clarifications.
Aaron.
Clarification, I think that the committee supported the residency requirement for whatever time you just read for the chair. But they didn't, that wasn't a requirement because it's not listed in the judge position or the prosecutor's position. They would have to after they are.
Correct. There's a difference there. C, the chair cannot be elected, appointed, or employed for the court, obviously, for the legislative branch, obviously, or any other government or other elected office for any other government, and may not accept any position or appointment creates a substantial conflict of interest. My only note is I'd want to make that a little bigger. Use of a term such as substantial is unwise because it leads to litigation. We've seen this in US v. Michigan. I think the biologists for the parties to US v. Michigan have been fighting about the term significant going back to 2008, 9, 10. So when you use those kind of words, you really need to be careful because it is in the eye of the beholder. So, for example, I wouldn't say a substantial conflict of interest. I would say conflict of interest, and then I would jump up and down until you adopted a proper conflict of interest ordinance that would govern all these kinds of things. So C is on the right track. It's obvious, has to be in there. Just playing around the edges to make sure it's clear and concise with the possibility of follow-up enabling legislation. 5, powers. Executive power shall be vested in the executive branch. The branch shall execute, enforce, administer the laws and budgets of the tribes. My comment here is that's a sentence, and I'm envisioning just like the existing board powers in the current Constitution, a good page. We will want to enumerate the powers of the new legislative body in great detail and with great intent, just like we will want to enumerate those same powers in the executive with great clarity and with great intent. The sentence is not enough, we need more. Otherwise, we will be in court forever. So what I would do here is I would just, there's a lot of good tribal constitutions out there. I'm not going to write from scratch. I would grab you a couple examples and we'd share them and say, here are the powers. It's kind of to Kim's question, is the chair and over top of the government. That's where you would find those details. It'd be buried in those various clauses. We don't have them now, but we can get them. 5A, under the direction of the chair, the executive branch shall present a proposed balanced budget to the council, the board, no later than the first day of June of each year for enactment the subsequent year. Fair enough. This kind of thing, I'd probably ask our CFO and our budget department, you know, have any comments, any thoughts? What do you think? Chair shall serve as the official representative of the tribe, and goes without saying. C, subject to legislative override, we're back to the veto. The chair shall have the power to veto a bill within 10 days. So the veto is mentioned twice. We would boil that down to once and make sure it's in its own section. I don't know why it's in here twice, but we clean it up and put it in one time. D, the executive shall not have authority to spend money unless authorized. We talked about that previously. We have a lot of past examples of that being an issue. E, the chair shall be authorized to hire staff in the office of the chair. Such positions shall serve at the direction of the chair and shall be vacated to coincide with the expiration of the chair term. This would be the chair's direct staff. During this term of employment, the chair staff shall be subject to the tribe's personnel policies of government employees. Funding shall be included for 4 such positions, and any additional positions shall be established by legislature. Some of this is administrative in nature, maybe needs legislation, and as I've said a couple times, I'm really uncomfortable including human resources language in the Constitution. Off the top of my head, I would say that the chair is authorized to hire a staff to his, to facilitate the conduct of his duties while in office, and the budget shall be adopted, something along those lines. So the difference between how E is written now and what I have in my head is just you want to, in very broad terms, convey that power, identify it, and leave all the nitty-gritty, all the nuance to either policy, procedure, or to follow up enabling legislation. The danger to doing it this way is when reality hits and the office of the chair wants to do something a little bit different, you're going to court because it's in the Constitution. It can get in the way of governance. It's easily fixable.
Okay, Aaron.
So prior to me being chair, the chair had a fleet of immediate subordinates, direct reports, and also supervised the executive leadership of the government. And when I became chair, there was a bunch of argument over whether I should supervise anybody. I was allowed to supervise less people than the prior chair, directly reported to the chair. And then all of that was eliminated in 2016. So the chairperson right now, contrary to popular belief for people that are watching this, doesn't supervise anybody, not even the staff that works in the chair's office, because of arguments legislatively not allowing that person to report to the chairperson. So, but the check and balance here, so that nobody, starts writing nonsense about it, is that the chairperson doesn't get to employ or supervise anybody unless the funds are appropriated. And so there could be games played by the legislative branch, but hopefully that won't happen because the chairperson has to be able to do their job and should have at least a core staff. And I'm not talking like a big giant number of people because they have access to all the departments of the tribe, but I think there's minimally 3 or 4 positions that the chair should have working in the chair's office. And I would ask any board members who don't appreciate that to go in and sit down in the chair's office and see the log of all the mail in, mail out, all of the requests for consultation, all of the documents that have to be signed by the chairperson of the tribe, and see the volume of work that exists before they conclude that there's no need for the chair to have any support.
What I would add to that is anyone that wants to shadow me for a week can. It's a job that's way more than 40 hours, so absolutely.
And anybody who wants to be chair should run for chair.
Okay, let's see. F, that actually, Josh just whispered in my ear. Josh made another good catch. There is nothing telling us what to do if the chair is vacant under this model. So we'll put a pin on that. We will want to address how to handle that situation. F, no person shall make or participate in making an executive decision if such person has a direct or personal financial interest in the outcome of the decision. Clear as a bell, obviously you have to have it. The way it's written, though, it is widely open to interpretation, and it would need to be reworded, and I would point back to my earlier comment that we really need an ethics or a conflict code to handle these types of things. And this one, no person, they're not talking about the chair. They're talking about, apparently, so anybody cannot participate in that kind of decision-making. So I want to kind of put more time in that one. And it's so open and so vague. And because we're having 3 branches where we have litigation, this is one where we most certainly want legislation that clearly, unequivocally, and if I can say this, finally defines how we handle ethics and how we handle conflicts, both for elected officials and for staff. Need it forever, everybody knows it.
The current process for staff is that they are conflicted out, but there's no requirement for self-disclosure. The same is true for the council. There's no requirement for self-disclosure of a possible conflict of interest. Also, it's a political decision of the board of directors on whether a conflict exists. The Constitution is clear that no board member shall vote on a personal interest, but then it's up to the board to decide through a vote on whether there's a personal interest. And I've seen people vote where there's a very clear conflict of interest with personal relationships with other board members. That should be black and white. It shouldn't be allowed. It was allowed. And nobody should be able to be involved in any decision-making of their immediate family. They should be recused. They should be required by law to not be in the room. It shouldn't be up to a majority of the board to decide if that person's got a conflict. Because if that person has 6 other board members that are willing to rubber stamp it, then there is no conflict. It shouldn't be left to that. There should be a requirement to disclose, especially if there's prior business relationships. We've had board members that have worked for vendors that haven't disclosed it, that have lied about it, that shouldn't be possible. So they should be required by law to disclose it. If they fail to disclose it, then they should be automatically removed from office because it doesn't allow for the government to decide if there's a conflict of interest.
Chair shall present an annual State of the Tribe address. Section 6, chair shall be paid. Comment on reasonable. I don't know what that means. Someone's going to get sued. I'd take it out. Chair shall be paid, or chair shall be compensated, just period. And leave it at that. Including a word like reasonable just opens the door because reasonable means it's in the eye of the beholder. Next article, sovereign immunity. So we have a pretty large code on immunity, and it is incredibly important. We rely on it quite often, and while we have lost in court on this issue once or twice, they were notable, we win much more often. I think since Josh has been in our office, he's handled 2 or 3 of these already. It comes up quite a bit where people try to subpoena things from the tribe and we push back. So what I would suggest here is the code as written most certainly needs to stay in place. It is incredibly important and it does a good job. It's a good code. I would suggest what we put here is just the large grand statement that the tribe has immunity. Basically section 1, 2, 3, and 4 just shrunk down a bit to the grand statement that we have immunity, tribe enjoys it. At the end, you see chapter 44, that's how it works. The rest of the code, rest of the Constitution is the existing stuff, which as I was typing this, I was trying to keep in mind where areas of conflict would be, but that is a kind of another part of the project. I don't know what we need to change, for example, vacancies and removal, or are we going to do right or referendum or not? All the questions, are we going to remove the secretary from the amendment section? Is that coming out? How to handle the bylaws. I don't know what to do with all of this language until we decide what we're doing with all of the red stuff up here. So I've gone through the document. I'm not going to go through how it meshes with those lower sections. That can be a different day because I need more direction to do it. That being said, I think I am done.
All right, Aaron.
Are you saying that those other sections should be considered because items that we are considering have implications for those other sections?
Yeah, they'll impact each other.
Okay, because those are not in what Rob had proposed.
Correct. So there's there's the large 2012 document. What Rob's resolution proposed to the board via resolution was a constitutional amendment that takes the separation language from 2012 and imports it into the existing constitution, which is why Rob called it an amendment. It's not a new constitution. So all this stuff way down below still stays, membership, all the bylaws. And as the red language becomes firmed up, we'll know what down here in black needs to move or be changed. Terminology, removals. Josh had mentioned that we're missing language on how to replace a vacant chair position. That'll trigger conversation about removal because the terms are different. There's a bunch of work that flows down. I can't do it until I know what the red means yet.
So I agree that if there are implications from what we're requesting, not from what we're not requesting, that if it implicates other sections, that those need to be updated. And I also think, and I think that we did have some level of conversation about this, the Elder Advisory had recommended in addition that we revisit the referendum threshold, because that was done. I believe it was done by accident. The board didn't intentionally. I know there's a lot of people saying it was done on purpose. When we automatically registered to vote for the chairman election, everybody, it created a higher threshold for the 30%. I don't believe the board intended that. The board never talked about that because I watched all those movies, all of those horror movies, no, all of those videos. So we could probably revisit that and see if there's a way we can tweak the language for the referendum to be 30% of the registered voters or something like that, of those who register. That would be an easy way to do it. And the other thing is the board received yesterday or the day before a draft cost for implementation, which far exceeds what the board requested. So just so that it doesn't become an argument that people are saying that we're talking about all that because we're trying to create this big number so we can't implement. The legal, I don't know if you guys work with budgets, but you drafted up what that looks like, but we don't really need all of those expenses for stuff that we're not contemplating. I think we kind of crossed that bridge last week when it became apparent that only 4 board members support putting out to a vote the entire draft that the 2007 and 2012 drafted up. So we don't need, my opinion is we don't need all of those numbers that come to almost $10 million, because that's a big ticket. And I'm not impugning anybody's integrity today, but that is what was done in 2012 in order to not move forward, because then board members, well, we can't afford it, we're facing a deficit, we can't afford the cost of sovereignty or to evolve as a tribe. So I say let's not look at those items that we never requested, just the cost of the items we have requested. And then if budgets was not.
So he worked with Bob, those numbers are what we are doing today.
But I see in there,
That's obviously not.
I saw in the draft, I saw the additional representatives. We never requested that. And the costs are projected in the cost.
No, so that, okay, so let's get into the reality.
Okay.
So that's what's going to happen unless we take that language out.
So that's in the draft legislative section?
It exists right now.
So I
So
don't
if we-
think
if
that's
we pull- if we-
Rob's intent. That's
If
not
we,
my
if we
intent.
pull it out, then it goes away. That's why it says in parenthetical, this is probably going to go
So
away.
that's why you guys drafted it that way?
Yep, so
Okay.
that's the reality, but it's more than likely not going to happen, obviously.
Right.
But it's I want you to know it.
Okay, because I do support, and I've said this, and it might confuse people last week, but I do support the entire draft document. But if we don't have 7 votes, we're wasting everybody's time by talking about that whole document. So let's talk about what we are talking about, which is separation of powers. I also think that the Unit 6 and the additional divisions of units in the Upper Peninsula, all of that, I think are meritorious, and I support those, but I also don't think we're going to get 7 votes for those. We won't get more than 4 votes for those. So I think that that's not on the agenda today, so we shouldn't talk about that. I don't know if the Mackinac Band expenses are part of this, but that's also not something that we're contemplating, so we shouldn't be looking at any cost of any of that. We should only be looking at the cost of what we're considering, or what a majority is considering.
Can I add something to that, Aaron? So I just wanted to say something about the referendum. So early in the chairmanship that I've had, I think we had 5 or 6 referendum attempts. And out of those 5 or 6 attempts, I think only 1 had a sufficient enough amount of ballots sent forward for the board of directors to even make a decision on it. So that was before people were automatically registered to vote, right? So for people to make the argument that we've made it more difficult for people to make a referendum successful, that's ludicrous, because when you look at the track history of the last couple years, you'll find that people haven't cared. You know what I mean? And that's just the cold, hard reality of it. And I have never heard of a voter registration drive like the one we did demonize the way that we did, right? And out of those referendums, if you add them all up, it's over $100,000. So when we have conversations about government fat, that's one of them. And back in the day, those referendums could be started by 100 registered voters signing a piece of paper. I can get 100 signatures before the day ends. It's not difficult, and you shouldn't be able to stall the government of the largest tribe east of the Mississippi River by having 100 people write something on a piece of paper at the cost of well over $100,000 after it's all said and done.
Yeah.
So that's that. And then,
Maybe can I answer to that?
yeah,
So I wouldn't say that people don't care about it. I would say that the people that are watching and paying attention supported the board's decisions as they made them.
they didn't care to overturn our decisions.
Right.
They didn't care enough to overturn our decisions to check a box on a piece of paper, put it in an envelope, and send it back.
I would characterize that there is a group of disgruntled tribal people who don't like who was elected. They don't like the fact that you were elected. They don't like the fact that somebody else was unelected. And they circulate out to try to contravene and frustrate the operations of the tribe, to overturn the tribe as in creating a problem for the operations of the tribe. So I think the solution, though, because it wasn't intentional when you guys voted on, because I watched those meetings, you guys never talked about this is how we're going to get the referendum people out of the mix. That never happened. But I do think that the 100 signature threshold happened at a time when we had 2,000 members. When we became a tribe, we had just 2,000 members. A lot of the people on this board were not members at the time, neither were their family members. My family was. But 100 out of 2,000, that percentage, maybe we should be looking at a percentage and make it more reasonable today, because 100 signatures. Now, on the other hand, I'm going to say when a referendum has worked.
So that ends up being 20% of the registered voters. If we had
20%.
2,000 people back then, and if it took 100 voters, so let's apply that today,
Yeah.
with 60,000.
No, it's probably 38,000, no, 34,000 adults.
12,000 people. If you had kept that percentage the same based on what the membership was back then and the signature requirement, and if you were to keep it up to date with that percentage with what our registered voters are and our membership is right now, you'd be looking at about 12,000 people.
Yeah.
I mean, it's crazy. 100 signatures, that's a joke.
So one other comment on the value of referenda is, when I left office, we had a former board member basically lobbying to get the board to approve a business deal with a business partner who ended up suing us for $88 million. And that initial plan came to the board voted for it. I got the 100 signatures to kill it, because it was basically giving away our resources, giving away our land, and the people of the tribe voted to kill that referendum. Then the people did vote to support the Lansing and the Romulus plans. So some deals like that, if it's a bad deal, because we were going to partner with the Greeks, they were part of the deal, and Jerry Campbell was part of the deal, and the people had the right to overturn that. And we did.
Yeah, no one's saying that. They should have the right to do that, but 100 signatures, it should be proportionate based on our membership and our registered voters. Like I said, 100 signatures, my God, we're tribal government. ARPA alone, in CARES Act, we controlled $500 million. 100 people can stall that spending. You know what I mean? It's crazy. The last thing I want to say is, so we hear a lot of campaign promises about separation of powers and checks and balances. Today you heard what that would look like, right? And judging from the looks on some board members' faces, it all of a sudden looks like some of them aren't supportive of that once they find out that, okay, there is a check on authority. There are balances. If you have a separation of powers, you're going to create multiple branches of government that are going to have to interact with one another on equal terms. And some people aren't okay with that. So, who wants to speak? Kim.
Okay. I'm tired of you guys saying we're not here to do our job. I have heard it like 5 times already today. We were called dishonest for being here. We don't care about what's going on here. We're here. We're here to do it. If we didn't care, we wouldn't be here. So, and I don't know who's sitting here making faces. I know I sigh every now and then, right, Rob? But I brought a referendum forward, and that's because it was near and dear to my heart for the Recovery Center. And I don't need a lecture on how that would have cost us. We had the money set aside. I thought it was a good idea. It failed. Aaron, you're always saying if you don't, something doesn't go your way, you're going to referendum it. I see it all the time. So referendums can be abused and they can be good. It's just got to be put into the language. And Aaron's working on that. So now are we able to comment on everything that he
Yep.
read to us? All right.
Yep, we can go through it over again if you want to.
All right.
You know, we can be here as long as everyone needs us
No,
to be.
I got notes.
Okay.
Now, the chief being referred to as the Ogama, in all my time of research, and I have never seen a chief from this area referred to as Ogama in any of the history. So if anyone has something out there that they can show me different. First time I've heard this was, I think, Little Traverse Band started referring to their chief as
Can I jump in?
Ogama.
Kathy
Little
DeVoy
River.
always calls me Ogama, our cultural director.
That's something that just started like 15, 20 years ago.
So we
I've
can
never heard
have
of it
someone in the
before.
language and cultural department look up what our traditional term is.
Yeah.
So we
because
can do that.
I've
But I
never
think if we're
seen it.
going to do it, not to interrupt, I'm fine either way. So if we want to have corporate titles, that's fine. We can have board, we can have chair. If we want to have government titles, we can have legislature, president. If we want to have traditional titles, we can have council, Ogama, chief, whatever you guys want to do. I think it needs to be consistent
Let's
across
see
the
what
board
the
though.
history, because like I said, I've never seen it in what I've read. So if there's something that they do have out there, I'd like to see it just because I'm interested in history. So, and then Aaron, we got to the Bill of Rights, G on the page 3. And that, I think we all discussed that pretty much there is an appeal process in place. We may not agree that it's a good one, but I don't think it needs to be in the Constitution because we do have it. No, it's the discharges of any person from employment without due process or takes private property, because we do have something in place for that already. And again, he kept saying he doesn't think employment HR should be in the Constitution, so. And then there was another one, H, on page 4. I put, when this be in the HR policies too, but I see you wrote duplicious.
It relates to the one above. It's an employment issue.
Okay,
An employment rights effort would cover both these, which we've talked about endlessly over the years.
okay, and then K, I wrote, wouldn't that be like an equal opportunity? Would that be in our HR too?
No, it's, K is just a core constitutional protection, an equal protection clause.
So that stays?
Yeah, that's
Okay.
good. It's everyone's equal under the eyes of the law.
All right, I'm crossing that off then.
That's outside of preference though, right?
Outside of preference.
Indian preference
Oh,
Tribal preference.
or tribal?
oh, that's perfectly fine. You're talking about this right here?
Okay.
Yep, that's okay.
Okay.
Okay, and then N, denies any person the access to his or her own personal information maintained by the tribe. Now, doesn't the Privacy Act and, like he said, HIPAA laws, people fall under that? Because you can get your own information, it's just other people's you can't touch.
Yeah, so when we talked about N,
So does that need to be in there?
I find it odd because of the way it's written, and you can't tell the intent from it. And if you can't tell the intent from the language, you should be concerned. Aaron came in with the reasoning for it originally being included, which makes sense, but that's not what it says.
That's not what we practice today either.
Yeah.
We give people full access.
Yeah.
So to me, it's very much legislation, and there's a lot of things in place now, FOIA, for example, that address it, because this is an old document.
Yeah. Well, the Privacy Act is like part of FOIA, so, okay. And then on page 5, Section 1, territory, I put the second part of that, no territory shall be ceded unless authorized by law, blah, blah, blah. Could we move that to policies? Or do you think it should be left in there?
It makes sense in the Constitution. The only concern I have about this first sentence is that it not be the word ceded,
Okay.
not be confused with the word sold. So right here, we have no real property shall be transferred. So let's say sold.
Clean it up.
So because Sioux Tribe is one of the few tribes with a carve-out from the Non-Intercourse Act, we are able to legally sell fee land, which is a little bit rare in Indian country. So we are able to transfer fee land as authorized by law.
But that's different than
Ceded-
trust, right?
Different than trust.
Yeah.
Ceded is different than transferred. So I'm okay with it because cede is a very intentional word. And I'm okay with it being in there. It's kind of neat. I don't think I've ever seen it before.
Okay, and then the next section 2, jurisdiction, you said that was used twice, you're going to clean that up,
Yeah, it's
right?
covered in 2 different areas.
Okay, and then separation of powers, branches of government. I had a question of, you go down to the second sentence, no branch of government or official of any branch, blah, blah, blah. Any power in the Constitution on properly delegated by law And my question was, who's going to determine what's proper?
Well, ultimately, the court.
Okay. That's what I put a question mark by it, said the court, okay.
Yeah, that's why the word properly doesn't really need to be there, because either it's delegated the right way or not. And if we do it wrong, the court will tell us.
Okay. Then on page 6, composition of the Supreme Court. The Chief Justice shall have oversight authority of all matters related to the operations and administration of the Supreme Court. Wouldn't that be in their job description?
It's kind of an org chart thing.
Okay. Let
So
me write that.
it's administrative matter that it really doesn't belong here. It belongs someplace. I mean, it's fine if it's in writing. Some things aren't quite working.
Legislation, okay.
Just like it'd be odd to put in a constitution that, Josh works for me. It's an employment issue.
And we would see that in the org chart.
Yeah.
All right, cross that. Okay. Okay, that was my notes from something you were saying. Oh, and then page 7. Let me see, I wrote it here. Judges, qualifications, A, judges, 3 judges shall be attorneys, and then the event, a qualified sui trium attorney does not register, the council legislator shall appoint an otherwise qualified attorney under the government HR. What if we keep getting turned down? What happens then?
I retire?
Can they turn us down if we pick somebody?
Yeah, it's an appointment.
Okay.
Yeah. So we've always been able to populate our court, although sometimes it takes some effort, I'm not gonna lie.
Okay.
It's a little bit of work. We just went through it recently. But it's doable. I think the key there, Kim, is to make sure it's done timely, that it's not last minute, because it's a bit of a crush. So it's doable, but it's going to take a bit of work. Specifically for 4A, on my implementation memo I sent you the other day, I just kind of warned you, like, we make sure we have time to put this together. That's one of the things I was thinking of. If this goes live, that court has to be turned on and ready to go. We can't have this be approved, signed off by the feds, and we're ready, and the court's not up and running yet, because it's going to take time to fill those holes.
Right. Okay, and then on page 12, all the rest of the ones, my notes were just things you had said that you were going to probably change in there, the little words. Okay, now as legal, would you recommend this be in the Constitution or our bylaws? That's number 4.
So that's a good thing for bylaws. If we're going to have bylaws, if we're not going to have bylaws, it can stay in this section somewhere. You want, the core basic rules of how you conduct business can be in here. If you're going to have bylaws, put them in the bylaws, the core basic tenets. I think the problem with how this one's put together is they're all very separate, and they don't really belong in one paragraph. It's more like this in some sense.
It's more what?
See how I broke them out on the screen?
Oh, okay. Yep.
So when you break them out, it changes how you look at it. So this one, yep, that is a very good thing for a bylaw, because it's core. How you take votes, roll call votes, how you vote is kind of a parliamentary rule. I kind of lean towards 14 on that one. If you want to require roll call votes for everything, that's perfectly fine. It's very strict. It can obviously extend business. So if you don't recall, I'm on the Brimley School Board. And just by habit, they do roll call vote for everything. And they don't do the consensus or without objection. And sometimes I'm like, we could go without objection and shave 20 minutes off a meeting if you wanted to. So sometimes you want to let the body kind of develop its own rules. And third one, that feels like a 14 too. But it is in the eye of the beholder.
Okay. So the ones you make comments on that similar to existing bylaws, we're going to have to determine if we're going to have bylaws or just a constitution, right?
Correct. That's a good way to put it.
Okay. And then we had I on page 13, move to chapter 10. All right. And I think that's it. Other ones were just, my notes were just things that you had mentioned. And one more comment is, I think if we want to get something done, we should concentrate on the judicial separation of powers. These other two are a pretty heavy lift. I think they're going to take more time than we're thinking. If we concentrate on judicial, I think we could get something done. Thank you, guys.
Okay, Aaron. Thank you, Kim.
So, I want to say this. I'm grateful that you're here, Kim. I've heard more out of your mouth than I have from board members that have promised a separation of powers for 20 years. And you're here. In 2012, in 2005 through 7, we were not permitted to go to those sessions. That was a specific rule that we were not allowed to attend. The board wasn't. Some board members did, but they violated it. And then in 2012, we did vote to reconvene the Constitutional Committee. The Board of Directors were permitted to attend then, and then the Elder Advisory. I won't name them, but there were 4 board members who are no longer here who got paid, but they boycotted the whole process. So I respect, even if we disagree, I respect the fact that the board members that are participating, and you gave a lot of input. I completely disagree on doing a 2-branch separation of powers because it's not going to work. I think that the solution to the concern about what should be legislative and what should be in the Constitution, I think we do the template, the general template in the Constitution, just like the United States Constitution did, but we give a implementation date with at least 6 months, because it's going to take probably 4 to 6 months for the Interior to conduct it anyway, and we should be drafting up legislation to flesh out and fill in the gaps. So then when it does pass, because it is going to pass, it's going to pass. My prediction, and I'm always right on these, on referendum, and constitutional amendments, it's going to have over 80%, because people have been waiting for 20 years. That we're ready to go, that we have enacted legislation to promulgate, to be able to step forward. But here's the thing, even if we don't get it completely right at the first, we live in a constitutional democracy that took 250 years to write all of our rights and privileges, and it's an ongoing process. So we shouldn't use as the excuse that we got to get everything perfect at the beginning in order to do anything. Let's see. So some people are upset about this, but like some of the items like the Unit 6 or the at-large, those can happen some other time. I think the core of the separation of powers, the Bill of Rights section, our due process and standing in tribal court so we can bring a cause of action against the tribe if they violate our rights, those are all so critical. Those should not wait any longer. We've been waiting for 20-some years for this to happen. We shouldn't wait any longer. As far as the title, so I grew up hearing the term Ogima, which is chief, but I also know that the chair of the tribe is an elected official and is not the chief of the tribe. And that's no umbrage on Austin. I never claimed to be our chief. I know a lot of people called me Ogima or chief along the way, but we do have a chief. We have a Sugar Island band chief. I don't know if you guys know, but it's Abe Bully. And I'm sure the other bands have their chiefs as well. but the chairman of the tribe is an elected official. It's not the chief of the tribe. And so chief is also a misnomer. That's not even a word in our language. So president, I think, is appropriate. That's what Whitney Gravel is, the president. Larry Romanelli is Ogima. I don't support that for us. So I agree on that, but so I think president. So, and I appreciate the board members who are intently participating. I think that there's a greater likelihood from some of the people we have not heard from before today or before the last meeting than people who have actually campaigned and put it in their platforms. Because it's one thing to say that you support a separation of powers, but who has spoken about it since they got on board, who's actually actively participating in the process, and who's going to use the argument that we're not doing the whole redraft as the reason not to do anything. So I do appreciate those board members who are contemplating it, that are considering it, and I do think we're going to get more votes on the side of people who aren't splashy about it, aren't campaigning on it, because I think they're thinking carefully about it. And I hope that everybody comes along. I hope that we could draft this so that everybody could come along, but I will not support a two-branch separation of powers because that's not what the people want. That's not what the process has requested, and it won't work.
Okay, anyone else? Rob.
So first of all, I am in agreement with most of the changes presented here. I think that a lot of things can be legislated. I think that we have to be careful not to teeter on the line of imposing our will on a court that doesn't exist yet, where they should have say to promulgate their own processes. I think that we need to remain pretty vigilant in seeing to it that we're not overextending the board's authority into the judicial system, which would contradict the whole point of this. So I guess my hard lines on it will be that the court officials have to be elected by the people, unless otherwise, like we stated in here, there needs to be a process for appointment if a Sioux Tribe member does not run for election. I think that that's necessary. The court must also retain the authority to review the Constitution and rule on constitutionality of law. Our tribal members need to have standing in court. And I also agree that it needs to be a three-branch. What we would most likely run into if we did a two-branch would be a stalemate between the legislative and the judicial. And I think that the purpose of a legislative branch is to legislate policy and procedure, and the purpose of an executive is to execute. And I think that is to mesh the two. We'd end up in a predicament like we are right now, where it's very easy to point the finger. I think that if everyone has clear lanes and they provide a check and balance to one another, that's the way to go about it. So I think we have a good start here. I just think that we have to be careful not to cross the line of, are we imposing ourselves on a court that really should be involved in the process, even though they don't exist yet. Maybe some of the things that we suggest can be held off until then, especially if we're legislating it. So I think the Constitution, what's presented, can be slimmed down some to frame what we're looking to do without adding too much legislation in here. And I get why it's in here. It's because the people who were on the committee wanted to build in these protections, but I think there's a way to do it constitutionally and still have those rules promulgated by either the court when it's appropriate or the legislative branch when that's appropriate. So just a few of the things here. I think it was G where stating that it could be read as every single termination needs an appeal hearing. With an independent court with judicial officials that have good standing in a state and have a law degree and are bar certified. I think that if we worded that within the Constitution that grants the authority to the court to determine which one of those cases have merit enough to be heard, I think that that can limit how many of those actually get an appeal, and it's by qualified court representatives. So the court's not going to hear every single case, but they do have the ability to review it and show where, hey, maybe some legal boundaries were crossed here, and this member does have standing here, and it's worth us taking a look at. So maybe putting that in the court's hands would be the best way to do it, and they could determine which ones are going to move forward and which one lack merit. I think that would be a good fix there. I don't know what everyone else thinks. So with the rest of this, I think it's, I don't see us getting through it today, but I think we have to do it soon. I think our members deserve and want it soon. So if we're going to have to go line by line, and I think that before we leave today, I would like to set a date for the next time we do it, and I would hope that it's pretty soon.
Okay, Tyler, then Lana.
Yeah, thanks. I actually agree with
We can't hear you, Tyler. No, you're cutting out pretty bad.
Hear me?
Now we can.
Hold on. You can hear me now?
Kind of.
Okay. So I think this can be trimmed down quite a bit because it seems like Constitution and code are written together, whereas we only need to make sure that the constitutional pieces are intact. So I'd agree with that. I do not like G at all. I don't like even that boards sit on appeals now. That if there's appeal hearing, we need to just shift that over to the judicial branch if and when created. Totally agree with that. I agree with a lot of the red lines that Aaron Schlehuber shared. I had a lot of the same concerns. I still do have a few concerns that weren't highlighted, but I'll just redline those and send those to Aaron so he can explain those to me behind the scenes and I'm not wasting everybody's time. The one thing that concerns me is that the executive split the other day did not pass. I voted yes on it because I do believe that in the executive branch, I think that would be a good start. I also believe that we can start this in good faith by codifying a separation, or at least giving our court system the ability to do certain things on their own aside from the government. I think if we codify and move forward with that, it would show a good faith that our tribe is codifying a separation of powers before membership even votes on it. That would be a strong showing from us. It would give our courts more authority. It would give our executive the authority. That being said, three-branch government, clearly it's ideal, but 100% we need to separate our courts. So I am in favor of voting for a three-branch government, sending this out to the membership cleaned up based on what was discussed today. I sat patiently, I listened to what everybody had to say, I took my notes. Some of these red lines I didn't actually see. So there's even great information brought up by Josh today. So I appreciate that. But the one thing I will say to everybody is if what it takes to separate our courts away from us as a board is a two-branch government, I'll support that. If we can get everybody on the same page with a three-branch government, which would be ideal, I'll 100% support that. But our courts need to operate independently. So we need to find a way to come together to say yes on something and get this out to the people for a vote by the people. And then the other concern is what was highlighted in the actual Constitution that's not being followed is the fact of our board member ratio. I too think that needs to be addressed in this version immediately, because ultimately, if we give the courts the authority to read the Constitution for the Supreme Court, and that gets put forward, that's going to break us as a tribe. And not using that as any kind of anything else, but that needs to be addressed with this draft as well, because we can't if we're not following the Constitution as is, which clearly we are not, based on what was highlighted in our memos, we need to make sure that that is addressed with this iteration as well. That's just my personal belief. I am supportive of moving this forward, one way, shape, or form, or the other. But our citizens need independent judicial branch, and you know, I'm willing to compromise. I'm willing to do whatever we can to work together to get this out and get this approved. So that's where I stand. I'm not going to say that anything's stupid, because two of the most successful tribes in Michigan, Gun Lake and Pokagon, are operating on 2-branch governments. And then I also just researched that it looks like Nottawasepi also operates on a 2-branch government. So I don't think switching from a 1-branch to a 2-branch is going to make us fail. I think it's a step in the right direction. But again, ideally, we would have 3. And I would prefer 3, but our courts 100% need to be separated from us as quickly as possible. And that's all I'll say today. Yield.
Okay, Lana, the mic.
Yeah, I said plenty the other night when we were discussing this and voting on the review. So like I said before, whenever we voted to send it out, I always supported that when the members went and had held those that convention. Plenty of blame to go around for it not happening in the leadership in the last 20 years. So I think everybody that's sitting there can take that's been there longer than being new, can take some responsibility in that. It is a pitiful shame that we could never get anywhere. I'm hoping that we get the 3-branch, but I do like a few of the things that Tyler said, focusing on separating this court. We could even codify it in our codes now and start the process. We don't have to wait for that. There's some things that we can roll up our sleeves and do. So I'm going to support us sending the 3, and I'm willing to talk about the 2 as well. Because I've heard the fear that we would have a lot of litigation. And so what is the next step now? This is going to be cleaned up. We're going to get another draft of it, of what was changed. Was things changed today? Were they? I don't know the process now.
So what are your suggested moves moving forward? So obviously, we're going to schedule the follow-up workshop before we leave here today, but how would you like to handle that, Aaron? Would you like us to go through line item by line item, polling similar to how we did with the election ordinance? What are your recommendations?
Let me think for a minute.
And I can get back to you too if you need time.
Just give me it. I'm trying to organize it in descending order. Listening to, so Tyler said something that jumps out at me, then Lana just said something. So.
Jump in here, Aaron?
Sure.
Maybe pull out the human resource sections.
Yeah.
And just get rid of those right off the get.
It depends. We need to know what the board wants to do. So your attorneys can't craft documents for you if we don't have a strong sense of which way you want to go. If you want me to guess at that and start generating documents, I will. I'd rather have a sense of what you want to do. If there is a sense at this table that you want to move forward with the 3-branch, roughly as it is in front of you up on the screen, then what I would want to do is I would want to peel out all of those legislative things we've talked about. I would want to go through and tweak all those languages where you find ambiguity. But above that, and I said it earlier, I want time to have other lawyers look at this. Sitting here, Josh flagged 2 things, because every time you read it, more things jump out at you. I want somebody that specializes in constitutional law that I have in mind to take a look at it. I've had a thought of having the MSU Indian Law Clinic or the Matt Fletcher at U of M take a look at it, the kind of attorneys that do this specific type of work. I would like to clean it up. I would like to have a couple lawyers that specialize in this, give me their advice, flag things, make sure we haven't missed anything. And then what comes back to you is a document that's pretty well vetted. Because right now, it is not well vetted. It has not been thoroughly thought through. So if there is interest in the three, generally as discussed today, I would want to eliminate legislation. I would want to put a lot of work into cleaning the language, and I'd want more eyeballs on it besides just Josh and I. That's not enough review. Then what comes back to you is a pretty well beat-up document that will still have a lot of questions that you need to answer. You mentioned going through Chapter 10 line by line. When we have a clean document where we know the questions, we can ask those questions. The bylaw issue, do we put it here or do we put it in bylaws? I'd want to go through all that work for this. If that's the road the board wants to go down, that's the direction I need. And I'm going to tell you, that's not a week. That's not 2. That's a lift. I want to do it right.
You hear that, Rob?
And I have one more comment before I give the floor up. You said the 2-branch government right now, Pokagon, and who else are running a 2-branch government?
I'd mentioned Pokagon and Gun Lake.
Gun Lake, okay. And where's Matt Weeson now? Aaron, do you know?
Pokagon.
Is he still in Pokagon?
Yeah.
He's just
chair.
reelected up there, yeah, a few months ago. Before that, he had retired for a term.
Do you have any, he's a good person. Do you have any kind of relationship with him, Austin?
Yeah, he sits next to me when I chair United Tribes of Michigan meetings. He helps me out with that. Yeah, I have a good relationship with him.
Good. I would make a suggestion that, and he's a very thoughtful man. I think that we could invite him up here to have like an unofficial sit down with the board so he could talk to us about that. He's got a lot of experience. He's a good person. And I just think, we should extend that and see, and, you know, for the new board members, you know, we've been living this constitutional reform for a long time, but it's a lot when you're new too. So talking to another leader from a different tribe that went through it may be helpful. So, and I plan on calling him myself anyways, because I do have a good working relationship with him. So to get his thoughts, but as a whole board, invite him up here for a dinner or something. I think that'd be worth it.
Yeah, I'll give it some thought. I will. Who else has their hands up? Okay,
Well,
Mike, go ahead.
Maybe ask the board if they're willing to do it. That's not respectfully, that's just not your decision. That's
I mean, if
the
you
board.
guys want to invite him, go ahead. You know what I mean? He lives on the Indiana border. It's the middle of winter. Go ahead, send out an invite. I see him all the time, you know, so.
I think it's a good idea, but,
I got Mike first. Mike, good.
sorry, Mike.
One, I appreciate you coming here and saying about the 2-branch government thing. I'm a little leery on what's going to prevent us from moving forward. I will support, like Tyler said, I want to be amenable, and I would support a 3-branch if that's the way we're going to go. But you're coming here saying 2-branch is working for some, and the major concerns that most of our membership has would be answered with a 2-branch. Going to be able to take a lot of this stuff to court. So I think the 3-branch stuff, I seen those tribes in the news. You know, their elections, almost every single election they've had has been ended up in court. So those 3-branch governments, I have concerns in it, and it sounds like that's a heavier lift too. So I'm also looking to see what is the quickest way to get these amendments, that separation of power, primarily the court, a separate court, independent judicial branch. That was the primary goal of a lot of us. So if the 3-branch government sets us back months and months to get it right versus an independent judicial branch, that's a quicker way to go. I don't want to lose this momentum. We have momentum going to get constitutional amendments. I want to see it move forward. I know people are going to have problems with the three-branch government, so I don't want to see it derail the whole thing. But at the same token, I don't want to derail it if that's the route we're going. I will go that route, but I do think it's going to be problematic. But I guess there are problems that I'd welcome at this point, because without having an independent judicial branch, I will vote for anything that has an independent judicial branch, whether it's a two-branch government or if it's a three-branch government, because we do have a laundry list of problems that have occurred. And I do think that three-branch government will be problematic. I think the veto thing got brought up today, and there was comments about the referendum, 100 people shouldn't be able to do it. Well, one person shouldn't be able to stall government either. So it's going to be problematic either way we look at it. So I do think the veto has a lot of problems that will be in court. We'll be in court too often. So, and I get the whole, hey, we don't want to stop something because of the problems. But like I said, I will vote for anything that has an independent judicial branch at this point, and we can clear things out. But I also don't want to stall this, and we're talking 6 months, a year down the road just to get it right because we're including the executive branch. So I guess I'll leave it at that.
Okay, I got Kim. Did I miss anybody? All right, Kim, then Rob.
Okay. Do you think Matt would come here? I don't, would the tribe let him, or would that be a decision of his own?
No, he can come on his own if he wants.
Okay.
He probably would. I'm sure he'd be happy to.
Okay, and then, Rob, are you good with the two-branch? If that's what it takes to move?
I prefer three.
Right, but if it's two, that's,
I don't know. I see this.
because you're the one who brought all this forward, yeah, so.
He's already stated 3. So, Rob, go ahead.
Yeah, I think after sitting here thinking about it, and I came here with an open mind, I had a conversation with Aaron earlier about the two, and the one thing would be is to see that the chair had executive authority to do that. Mike's right. The main focus is an independent court, but I think if you talk to almost any employee in this tribe, the other one's micromanagement, and it's asking people to answer to 13 people that really have no day-to-day oversight. It's ineffective. It doesn't work. It's never going to work. And I think that our employees should have a constitutional right to have a clear chain of command and an executive. And also, I have a huge problem with mixing legislation with execution anyways. I think that's the point of having a 3 branches, where you have a legislative body that sets policy and procedure, and then an executive branch to provide the proper checks and balance to that to execute. I mean, it's almost the same thing as separating the court and the legislative body. Why would you want your legislative body to also have the ability to interpret the laws and rule on laws that they create? I think there's a discrepancy there to be said. Why would you want your legislative branch to also be the branch that executes? Because are they going to blame themselves for getting it wrong? I think that the 3 branch is the way to go, because each one has its own function, and I wouldn't want to see any branch have multiple functions, because we are a prime example of how it does not work. So I'm pretty dead set on only supporting a 3 branch at this point. I just don't see how it could be effective that we set the laws, set the policy, and then execute. And then who do we blame when we get it wrong? There's no clear lines of whose authority that really is. As far as the process on moving forward with this, I'm okay with getting other eyes on it, but not until we go through line by line and finalize what we have to here. I don't think that I like that we did an overview today, but we haven't gone through line by line and made sure that we fully got what we wanted as far as before we put other eyes on it to get it back. So I think it might take 2 reviews, one before we allow another set of eyes on it for attorneys that you recommend, Aaron, that have constitutional experience. But then when it comes back here with their suggestions too, I think that we need to make sure all of the protections that we want in there to isolate the court, and to make sure that those rules, that we're not overstepping there. So I think that we do have to have one more session where the board goes through line by line, and we know exactly what we're sending out to get anything further on it. But I really want to set a, I know you said it would take weeks to do, but I want to stay on top of it, and I want to set some timelines and have some dates, because I know how this can get out of hand. It could be 7-8 months from now, and if we don't act on it, and if we don't take action to set some time frames, it might end up being a lot longer than any of us want.
Okay, Aaron, then Lena.
So I'll try to say this as respectfully as I can. The notion of a 3-branch separation of powers appears to be dead. It appears, because several people are asking each other who's on board for a 2-branch, that there may be 7 votes to move forward on a 2-branch. I don't support that, and the reason I don't support it is if we went over to Bawating and talked to the 8th graders, because they're learning about the Constitution, separation of powers, and fundamentally, you can't say that you want to eliminate the micromanagement and operations of the tribe at the board level, but then not be willing to separate those administrative functions out from under your legislative duties and responsibilities. There's something very intoxicating when you're elected and you get to basically be judge, jury, and executioner. In this case, you don't get to be the judge or the jury, but you are still the person who writes the laws and implements the laws. And not separating out the executive branch and the legislative branch, either we didn't do a good job to explain why that's necessary, and throughout the day today, I try to be very respectful to walk through examples of collusion of where a legislative branch is stepping into administrative decisions. Like the big one is the appeals process. Another one is when you don't like the appeals process to the extent that it exists, when board members bring, either board members or they say they're just supporting people when they bring their issues forward, to overturn the decisions that we already have in place, the processes that we already have in place, there's a lack of humility there because the legislature is unwilling to let go of the administrative functions and duties of the tribe. So there's few people, I give some grace here. There's few people who know what that really means, and it's the people who have had to do it, people who've been on the legislative branch and the administrative branch. I will tell you, and we've talked about this repeatedly, we have difficulty recruiting Native American people, our own people, to come work for us because they laugh at us because there's like no way they're going to work for us when they believe they have to report to 13 people and that their very employment is contingent on whether or not 13 people, they're in political favor of those 13 people. I've watched decisions made from this table that have more to do with politics on those key people, those key personnel people, than anything else. We have a board member that's making that argument, made that argument in last month's paper. And so we need to either be real about a separation of powers or not, but it doesn't matter because I'm outvoted. I'm glad that Rob's sticking to his guns on the 3-branch separation of powers. That is not what the Constitutional Convention Committee drafted up 20 years ago. That's not what the Elder Advisory Committee has supported. That's not what the tribal members have supported. So I don't know where this 2-branch is coming from other than the very people who did not support in the drafting of the 3-branch separation of powers. we've heard all these arguments that it's not feasible, it's not functional, it won't happen, it can't happen, and that's nonsense, because we are in a country that has a three-branch separation of powers. It's not perfect, it's got its problems right now, but it's better than a two-branch where there is no check and balance. So we also heard some arguments that I think, I don't know how strongly I feel about this yet because I got to go back and look at it, that will diminish the separation from the judicial branch. A lot of the functions were argued today that don't need to be in Constitution, but can be legislated, but they can be legislated in, they can be legislated out. So I think that's why the committee in 2005 through 7 erred on the side of putting items in the Constitution because they didn't trust that the legislative branch would not respect the separation and would start intruding and dismantling the judicial branch. So if we do that right off the bat and we take out those key functions that the court may have, then we don't have a separation of powers at all. So, so I think for transparency purposes, I think the members will see very clearly what a two branch is versus a three branch. They will not consider that a separation of powers at all. And I think that it will fail. I think when it goes out to a vote of the people, it will fail. I'm not going to say that board members, that's why they're doing it, because I do think some genuinely think a two branch might work, but I think it's not a deep enough review of what a two branch versus a three branch actually means. It will not change at all the frustrations of the chair's office with every little detail having to come back to the board of directors and getting permission, the mother may I, for every administrative decision of the tribe. It's not going to change that at all. So to me, it's an exercise in futility. I appreciate those who did give good faith to it today, but a two branch is not going to work.
Okay, Lana?
Yeah, I'm pretty frustrated with some comments made, so I better get my thoughts together and look forward to the next review that we have. You know, it's blowing out of the water that everything is running amok and everybody has to come back for the board to every single decision. I think that we have an org chart in place, and that org chart identifies who people have to report to. Nobody's calling me and asking me things on a daily basis. So whoever's making the decisions or getting inundated with all kinds of questions, I don't know who those are going to. So I wanted to make that comment, and I didn't hear anybody say that they're backtracking and only going to vote one way. It's a discussion that we're having. I would have, with my suggestion about Matt Weesaw, I wanted to hear the concerns he has with that as well, a two-branch government. So eyes wide open on everything that we're doing. I didn't hear anybody say that they were just throwing out the three-branch government. I never said that, and I don't really hear anybody else saying that. It's a discussion. So I'm going to leave it at that, but I do know, like I said the other night, we did 3 amendments to our Constitution. And if we can't get anywhere with the 3-branch or the 2-branch, we should absolutely focus on our court system and making that its own standalone. And I think Tyler said it earlier, if there's anything that we could do now to show the members that we're serious about the court, you know, we should be doing that now if it's an easy lift. You know, we can make changes to the way we operate without a constitutional reform. We just have to do it. So I'm there. And then Aaron, you know, you Schleober, you said earlier, you know, this isn't a week or it's not a 2-week. You know, just so we know, just so we don't see it on how long are we talking to be realistic with what we have to do?
Are you talking about this draft in front of me or the entire enchilada?
The draft, the content that we're working on, that you said you were going to go back, you were going to, you know, make some changes, tweak it a little bit. We're going to have another review. That's what a timeline.
I'm looking at my calendar.
Because like you said it's not going to be a week, it's not going to be 2 weeks. And then,
Well, it's a week, 2 week, then there's Christmas, obviously.
right. It's going to be,
It's early January. I want at least a week for us internally, at least a week for us internally. I want Ryan to have a good chunk of time to look at this. Ryan's next week is booked, and he knows that when he gets back in, I want him to get into this with me. Specifically, I want him to put an eye on what changes would need to be made to the election process, if any. I can't envision any. So I'd say the week of the 9th, I want to do internally. Then the reality is if I call some of the outside people, some professors, and say over the course of the week of the 16th, could you take a look at it and get me comments back? They say yes, they say no. So the 9th internal, I would hope the 16th external, which I assume is doable. With all due respect to the board, the 23rd, 24th, it's Christmas. You guys are not going to be on my mind that week, and that's just kind of what's going to happen, which puts us immediately there right after. I'll be very blunt. I'm not going to let you rush me on this. We have to do it right. It's not going to be a couple of days. It's too important. It's too complicated. We cannot make a mistake. I understand there's a strong desire to push this thing forward, but I'll be blunt. I'm not going to let you force me to do a bad job. I'm just not. We're going to do it right. If it's January 1st, then it's January 1st, is what it is.
thank you.
Okay, Rob, then Aaron.
So you said the week of the 9th, so should we meet the 9th and hash out, do the line by line, that way you could take it and get your...
I want a few weeks to have lawyers crawl through this thing, line by line, word by word, lawyers, and then come back to you with a fairly clean document that then we can go through line by line.
And Rob, just to add some color to what he's talking about. So
Well, I know, but we have a document here that Aaron has put through with the lines that we went over today. Our plan today was to go line by line and have input on it, which we decided at the beginning to have him go line by, or to have him overdo the whole thing. We still haven't had input on this to say what we want to go out. That's what I'm saying. I'm fine with Aaron taking his time and doing exactly what he wants to do to get it right, because I don't want to force, I don't want to push it on him like that, but at the same time, is this what we want sent out?
Can I add something to that? All right, so what I would suggest is to figure out exactly what all the proposed issues in this amendment might be. So Aaron's identified some, but even as he sits there, Josh sitting next to him is identifying additional issues. The caliber of attorneys that he's mentioning, people like Matt Fletcher, he's an attorney / law professor at Michigan State. He's a regular contributor on Turtle Talk. He's not the type of person where you snap your fingers and, yep, I'm available. So what I would recommend doing is having someone like that review it, figure out where all the issues may lie, and then come back and we can go through it meticulously, because you just saw.
I don't disagree with that, but.
Well, hold on one second, I'm almost done. We went from 10:30 to 3:30 just reading it. Like, this is going to take multiple days.
Okay, but we're not done with it. That's my point.
I know it.
We didn't accomplish what we set out to accomplish today.
We started the process. I mean, that's a big accomplishment.
I'm fine
on my
with
part.
getting those high-level attorneys on it. I think that it's necessary. What I'm saying is we didn't do what we said we were going to do today.
Exactly, and we have 5 people here. 7 people aren't even here. So we'll do the best we can. Aaron, what do you suggest we do moving forward?
I suggest that right after Christmas, I bring you back a document that has a lot of these legislative things peeled out, that has a lot of the language tweaked to reduce the ambiguities. And then what's left for board decision, setting aside the big ticket item of if you want to do it or not, is there are language down here in bylaws, all this black stuff, the existing constitutional language that will be in conflict with the new stuff up in red, and you make a decision on those. And by then, I will have, I assume I will have had an opportunity for other attorneys that specialize in constitutional issues take a look at it for us. So I would say right at first of the year, you get a slimmed down document that's a little more trim for your review.
So that's not that far off. Next week, you know, we've got some stuff going on. The following week, we have the comp studies. Week after that, we're off for the entire week of Christmas for the most part. Like, that's as quick as we're going to get it realistically.
No, I get that, but there's things in here that said we're going to admit it. We never made a decision to omit it. So if it comes back to us omitted, then we haven't really had, then didn't come from us.
And that's why I haven't edited this without your direction yet, because of Rob's concern, because it's not my decision.
So we just need some direction moving forward.
So what I'm saying is, would it hurt to meet on the 9th or something, go through all these line by line? That way Aaron has clear direction on what he's bringing to the other attorneys. I don't think that's completely out of line to ask for. I think.
Monday?
Yeah. And then he can have whatever time he needs to do it. But there's stuff in here.
You're talking about December 9th?
Yeah.
That's Monday.
Yeah, Rob, that's not going to work for anybody.
Why?
Well, for starters, I'm in Washington, D.C. to
Cincinnati.
meet with a lot of different congressmen and senators. I have no idea where the rest of this board is going to be. And you work for
They
a
get paid
government.
$67,000 a year. You tell them to be here, they better be here.
Some are
We
gonna
have
be
5
in-
people here out of 12, Rob. Look
some are
around.
gonna
You
be
think
in
they're
our
going to be here on
hearing
Monday?
On our treaty rights, or traveling down to Cincinnati.
We have the consent decree stuff next week. I mean, it's just a busy week. 'cause of
All I'm
holidays.
saying is that there's stuff in here that most likely could be legislated. But if it comes back to us and it's omitted, then that wasn't our decision to do that. And it's our job to do that. That's what I'm saying.
So if we do that, it just can't be on the 9th. That's too short a notice. When can we do that, Aaron? Just to compromise with
I'm
Rob?
at the point where I'm not doing anything without direct votes of the board.
The members, we're representatives of the members.
Who's here?
Did you talk to the members about what they want in this constitution?
Rob, look over there. Who's here? No one is here. Like, Joe, can you scan the audience real quick? Like, what membership are you talking about? No one's here, man.
I think there's 7 online, there's some watching on YouTube.
And we're a tribe of 60,000.
Okay, well, you still have to offer what you said you were going to offer.
I have never offered line by line. If they want to have that level of participation, they have to win an election.
Not in a representative democracy.
Absolutely, they
No,
do.
no.
We live in a representative democracy,
You-
and
you
I
might
can't
believe
show
that.
up to the
I
floor of
don't.
Congress, and I can't say
You
whatever I
might
want.
believe that, but I don't.
Well, I don't really care. Aaron?
So, so I hear the frustration. I also agree with legal that it's difficult for them to figure out what the heck they're supposed to be doing when, I mean, I conclude that there is not sufficient votes for a 3-branch separation. Lana, getting my hopes up by saying, why are we concluding that? Maybe we should poll today and give clarity to Schlehuber, because if there isn't support for a 3-branch, then I don't like that, but let's call it as it is. Let's give clarity to legal, because that'll direct which way they're going to go when they draft this up, because there's more work to do if there is a 3-branch separation, and they need to know that. They need to know when they should schedule it and start working on it. I think it's clear, because I'm not going to say that people worked it out outside of today. I won't say that. But it's clear that we might have 7 votes to do a 2-branch, but it's also clear to me that we do not have support for a 3-branch. But that's my opinion. Maybe we should poll to see if there is support for a 3-branch separation, because that'll give clarity to legal on what they need to be working on, because there's a whole lot of other stuff they got to do, and they should set their timetable based on that. I think maybe we could meet on the Monday before the 17th, the 16th. We could meet on that Monday and do what Rob said. But Rob, I think we did do the line by line just now. I think board members have had the chance for the last 20 years or however many years they've been on this board to read the drafts, and you, 2 months ago, it's 2 months ago that you submitted this, and you know, I don't need somebody to tell me how to interpret what's there. I do think it was helpful today. But I also think that people have already skipped way past that. I think people already know how they're going to vote, and I don't think 3 branch is on the table anymore. I think a 2 branch is, which I don't support. I'll sit here and I'll listen through and try not to be snarky or publicly, obstinate about what we're proposing. It won't work. A 2-branch separation doesn't resolve at all the administrative challenges that exist, and it doesn't sound like those that have that authority now want to let go of that authority. I think that they enjoy that authority now and they don't want to let go of it. So that's just my opinion. But so before I conclude, because I don't want to be the one to conclude it, is do we have any hope for a 3-branch separation?
So what my plans are, we'll finish up the speaking list, and we do have to provide some direction to legal on a couple different fronts, and then we'll do some polls then. So I have Isaac, then Rob on the speaking list.
Hey, Aaron, I want to thank you. I think you did a good job, even though you didn't know what the board again was looking for, right? I mean, the other thing is legislatively, right? If you bring a document that we've already seen and you bring it back in a week and you remove paragraphs, we still vote on that document. So we're still voting on those changes, right?
Correct.
So I can kind of hear where Rob's coming from, right? I've held my comments because I think it's going to be a long process anyways. And I want to see a little bit cleaner version where we're voting on the actual nuts and bolts of it and not everything else that should be over here, should be over there. But I do appreciate your effort, and I understand where you're coming from when you say that you're concerned that it's hard to write up anything when you don't have clear direction, because, you know, I'm undecided of a 2-branch or a 3-branch. I think we'd probably get a 2-branch in a lot sooner. I do have my concerns with about not touching parts of the Constitution, like the 500 members, a unit director representative, you know, the Mackinac ban issue. I mean, this the also the part where the chairman or a board of directors, you got to declare the vacancy open. I mean, we went through a lot of things in the past, and I know it's not perfect, but hey, it worked for 50 years. I do agree that the court's got to be separated, but I can see that their docket's going to be pretty full with all this stuff. But I appreciate all your help. Thank you.
Okay, Rob, and that's the last hand. And if you guys don't mind, I'll say a couple things, and then we'll provide some direction to legal how to move forward.
So I kind of disagree with Aaron. I think that we do have the votes for a 3-branch. I haven't heard enough people say they wouldn't, and I'm counting 7 in my head right now, and that's without even verifying with the other 5. So, you know, I heard Mike and Kim both say that they would prefer a 2, but they're not going to hold it up because of the 3. So I think they would move forward with a 3. I'm for a 3. Aaron Payment's for a 3. Lana said she would move forward with a 3, and I know Sean supports a 3. So there's 7 there, and then Isaac and Kim brought forward the full Constitution, which means in some sense they do support the separation of powers, and I never heard any of them say that just because that didn't pass that they would hold out on a separation of powers with a 3-branch government. So we just heard Isaac say that he sees could see it going both ways, and he's undecided. I think we have enough to move forward with this as a 3-branch government, and I think that if Austin takes the poll, I think we're going to see that the direction is to go forward with a 3-branch. And you know, I've heard a couple of people say that they would prefer a 2, but they're not holding it up if it's a 3. Mike just very clearly said he's adamant on a separate court, and if it means voting for a 3-branch government, Kim just said me too. If that means voting on a 3-branch government to get the separation of the court, then that's what they'll do, and I appreciate that. So I do think we have the votes to move forward with a 3-branch right now.
Okay, Bridget, Aaron?
So I'm not gonna say a bunch, but I will say that I would like to, before we start taking polls or whatever, that we bring in or send allow Aaron Slober to reach out to the other tribes in Michigan, Wisconsin, wherever, that have the different 2 or 3 branch governments, and maybe the pros and cons, any issues they see. Like he said, I appreciate the fact that he's standing up to the board saying, that, we're not going to rush this. He's going to do it right. And that's, all this back and forth about, oh, how many votes are going to support this? How many are going to support that? That's all nonsense. And it just infuriates me to hear that, because even if if not saying anything, that doesn't mean anybody knows how I'm going to vote or how I feel about anything. I'm taking it all in. I'm glad he went through the document line by line, told us what he feels there's issues with and whatnot. Unfortunately, there wasn't a lot of members online. I see some had put their hand up, and I don't know if they put it down or we didn't take the questions. I think that we could do, I wouldn't be opposed to him contacting and getting with these other attorneys, getting with these other tribes, bringing all that information back to us, and having something similar to this again, and maybe doing this one maybe from 4 to 8 at night or a different time. And I don't want it to be rushed. I know we need constitutional change. I'm in support of that, but nobody's going to tell me and browbeat me and shame me and all that stuff, because from this seat, I take serious responsibility in knowing what we can, what is actually going to work for us. And that's why I appreciate the experts that are going to be telling us this. And I'm tired of listening to all the things that have happened in the last 20 years and who voted this way and who did that and who. It's getting us nowhere to hear all that. I wish that would be stopped and just stick to the actual facts of people's opinions and whatnot, not about how board members are going to vote or how they feel or what they did. But anyhow, appreciate all what legal has done so far. Appreciate all the members, anybody's concerns. I would really just like to see all this come back to us before we start taking any polls or anything, so we have all the information in front of us. I don't want to say, yeah, I want to do 2-branch, 3-branch, whatever, without knowing pros and cons from other tribes. And I don't see why this can't be reviewed with the attorneys before it comes back to us, because it doesn't mean that the document has been changed. It's going to be, this is what they think we should do or what's going to work. Doesn't mean we have to take anything that they say and pass it. It's just saying what other people think about it and what will work. Thanks.
Okay, Aaron.
Okay, people can be tired of what other people on this council have to say. I'm not elected by other units, so I'm unconcerned about that. And I'll be as polite as I can about that. This is why we're paid 3 times as much as our average team member is paid. This is our job. It's not an interruption of it. And we have been waiting for 20 years. The people have been waiting for 20 years. Some have only been on this board for 2 years. Some have been on for 4, some have been on for 8, some have been on for 12, some have been on for 20 years. And we have no good reason why we haven't done anything in this area. So our tribe is broken. Our governmental structure, it was forced on us by the federal government in a IRA constitution with a chairman and a board of directors, which is corporate America. So I'm sorry that's an interruption or an intrusion, or maybe there are more important things to do. There is nothing more important. Some of the people I talk to have said, oh, we've been busy with a lot of important things. Well, you know what? There is nothing more important than having a real government. And I think there's a phenomena when you get on this board, you come in here like gangbusters and you make all kinds of promises. A lot of people made 3-branch separation of powers promises. And whether you follow through with your promises or not, that's your prerogative. You can do what you want. Some people don't have to be worried. I mean, the votes that they get to get elected, they don't have to care what the people think, right? The other thing is, while I respect Regina and Larry and Matt and Dory from the other tribes, those are other tribes. We're a sovereign nation. What we know that our people have asked for is in this draft, in the three-branch draft. So I don't appreciate thinking that somehow these other elected leaders from other tribes are going to come in and tell us better how to operate our government than what our people told us 20 years ago, and then in 2012, and then our elder advisory just told us. It's diminishing our own sovereignty when we think some other government can come in here and advise us how we should operate. So I do think and I have requested a poll today because it's being disputed that a three-branch is still is considered. And I appreciate, Rob, you kind of calming me down as a young person, breathing, yeah, let's breathing it back into it, because if it is going to take longer, you know, nobody has said at all at this table that we're trying to ram things down people's throats. That's the language we've heard. That's not helpful. That's to try to diminish other people's opinions about what we're drafting. And if it takes longer for a three-branch and we have to articulate that out and it takes several months to do it, I'd rather do it right. If we're saying let's do it right. So do we have support for three, or do we have support for two? Or if we're polled against 2 versus 3, what does that look like? So I do think we should not put this off so there can be side conversations to kind of twist arms after today. Let's find out where people are today. We don't have any reason why we shouldn't have an opinion about that because, again, some people have been on for 2 years, some have been on for 8 years, 12 years, 20 years. You should have an opinion about a three-branch versus a two-branch.
Okay, Lana, then Kim Gravel.
Yeah. I just want to make something clear to at least one board member. I think everybody else probably could respect my thoughts on other tribes and leaders. It wasn't to have them tell us how to run our tribe. That's ridiculous to characterize it like that. I wanted to know what was working and what wasn't working with the form of government they had. And knowledge is power. Schleober has cited so many different people that he goes to for advice on different things. That's a proper way to conduct yourself. And I think, and you know, we don't have to do it, but to characterize it that I want someone else to come in and tell us how to run our tribe, that's just crap. I never said that. That's not helpful. It's not helpful when we give our opinion and it's always turned around into something nefarious, like we're not going to vote for it and we're going to twist arms and we're going to do all these things. It's not helpful. I really like the way Rob described. He was fair about it. Nobody has said, throw the three-branch government out the window. Nobody has said that. It's another, I'll leave it at that. So I just wanted to make that statement about Matt Weesaw. Absolutely not. And I hope the board members with clear thinking there know that that's not what I was saying whatsoever. So I just wanted to say that.
Okay, Kim Gravel.
Okay, I'm willing to wait to see after Aaron goes and gets the advice of these other lawyers that specialize in this, because there might be more that'll support the three-branch once he comes back with a cleaned-up version. It might make it a whole lot easier to support it. I mean, I'm not going to stop it, like I said, because we need the separation of the court. And if it's going to take voting on the three-branch, that's what it's going to take. So, and I'm with Lana. Let Matt come and tell us what works for them. And they have the two-branch, correct? Yeah. So let's wait and see what's going on with that, and then we'll discuss it again at the next meeting. And I'm with you, Rob. The sooner the better. Well, we got to wait till he comes back with his stuff. So I'm thinking no later than the first week of January, hopefully, if he can get people to respond to him. But I want to thank everyone for being here today, too. And we do have 7 people on Zoom, 5 in the room, plus Austin. So there is a full house. And I thought we're going to let the members talk at 4 o'clock. Did I read our thing wrong?
I have no clue. Yeah, I have no idea.
Yeah, okay,
So,
all right.
couple things. I don't see anyone else's hands up, and if we need to do polls after I'm done speaking, we can certainly do that. So,
Austin,
Yeah.
I didn't mean to interrupt you, but I didn't hear what you said. Are we going to let the members that came today have a few minutes to say something?
So we did give them the opportunity. At the beginning of this, I said, you guys can speak as long as you want. I'll give you the floor as long as you want to make your comments. But after that, it's a board workshop. No one had their hands up. So a couple things I want to say. So we spent millions of dollars on the Constitutional Convention Committee, right? And they didn't want the board involved because I think they were probably distrustful of the board removing some of the power that they held, right? I mean, it's a conflict that we're having this conversation, but no one can make this decision for us, so we need to recognize that right off the bat. The other thing that we need to recognize is that we're taking a piece of what they did and we're changing it. So we're really not sending out what they proposed to do, right? So they came up with 3-branch. I can be open-minded, but there are certain items that would have to happen for me to compromise. Number one, the board of directors does not have any business and operations. If you ask anyone, it's a point where they'll become infuriated about it. You know, board members get voted out of office because of it, you know, because they stick their hands too deep into it. It's not needed, it's not necessary. The board of directors should be here to legislate, plain and simple. There should be a veto power over this legislative body, as there should any body, because sometimes when politicians get together, they pander to certain groups, and those decisions aren't the best decisions for us. Next week, we're going to be in Cincinnati. Some of us will be. I won't. I'll be in D.C. The board gave Mason Morissette $2 million. He slept. We all knew that. I mean, people were showed pictures of it. I would have vetoed the resolution that hired him. Plain and simple. I would have vetoed the resolution that caused us to go into business with Jerry Campbell without having any land and trust downstate to start a casino. There's no business partnering with a developer to build anything. Those kind of things should exist to safeguard the Sioux tribe. They exist to safeguard governments. So just because a certain branch of government has a veto power doesn't mean that one person is a king. On the contrary, there's checks and balances. We just heard from this document, if I or whoever the chair would be would put a veto on something, there'd be a way to reverse it, whether it be 2/3, 3/4, whatever it is. It's not the end of it. So when you have separation of powers and checks and balances on governments, it means that each branch of government stands on equal terms with one another, and there isn't one superior branch. There's a check and a balance on each one of them. Before I became a clinical social worker, my education consisted of having an undergraduate degree in political science. It's something I studied. You know what I mean? It's why each one of the 50 states that we have 3 branches. They have checks and balances. And it isn't a European model that we base it off of. It's based on the Iroquois Confederacy. What we have right now is a corporate board structure where, I mean, it's how corporate America runs itself. You know what I mean? It's not representative of the type of government that we have or that we strive to have. So moving forward, if we want to put what's sitting in front of us, which was the Constitutional Convention Committee's original purpose, to a vote, we can send it out. If some people are on the fence about 2, 3 governments, we can send both of them out and find out what the membership wants too. You know, you can very easily do that. But from the beginning of this, I told you guys I was suspicious of the board being truthful and honest about separating the powers because I've seen what's happened. I've seen them do things contrary to what this document says that they should do if it passes. That would be delegate certain authority to the chair's office. It would be stay out of appeals. I don't see that kind of stuff, and I'm a pragmatic, realistic person. I think it was eye-opening for some people here, knowing truly what a separation of powers is, which is why you're seeing one branch of government getting the axe potentially. You know what I mean? So, and that's just the cold hard facts of it. Like I said, I'm not going to stall progress. I'm not going to get in the way of things. I'm a realist. I try to be pragmatic, but if you go to, because like Rob said, that might not even be the direction. All we've heard from people is we're not going to get in the way of a 3, but if we need a 2. I would disagree. I think building the legislative branch is going to take much more work. I mean, you don't have anyone elected over there. You don't even have any tribal members applying to work over there right now as a judge. You know, it's going to be a challenge and it's going to be a massive lift. And that's just if we're being honest with ourselves. So I'm not going to stand in the way of progress, right? I'm not going to make a scene. I'm not going to do anything. Same thing when that vote got voted down. You know, I'm going to be professional like I always am, but there's certain things that need to change in this tribe for it to work more fluidly and to function better. I mean, when we get that employee satisfaction survey from the key employees, it's all going to be in there. It'll all be in there. So, anyone else? Yeah. All right. So let's figure out what the polls are, guys. We've said enough today, if that's okay. So let's figure out what the polls are. So we want to see what the direction is from the board, whether it be 3 or 2.
And I think we should be able to express whether we support both. So like ask for 3, everybody that supports that, then ask for 2, everybody that supports that. And, you know, there's one final comment, is when you think about whether or not the people will support, I mean, we're being asked if we will divest our authority. Well, of course, you know, a body doesn't want to separate their power. And thinking that it's tenable to separate the judicial authority from the legislative authority, I do appreciate that. But we're hearing people saying, I can support that. But there also seem to be saying, I can't support divesting the administrative authority because I appreciate having that authority now. I'm not willing to give up the administrative authority. And who are we to stand in the way of the voters of the tribe to not let them make that decision? I don't appreciate denying them the very opportunity to tell us if a 3-branch is tenable, if that will work in their minds. I don't appreciate that. Now, you can say, well, we are representative to democracy. It's our right to represent them whether they like it or not. And if they don't like it, they can vote us out the next time. But wouldn't it be better just to invite the people to tell us if they support a 3-branch, rather than those who have complete unitary authority over all branches right now being unwilling to separate their own authority and give up their own authority? That sounds pretty selfish and pretty self-interest.
Okay, so I got Lana, and then let's really try to focus on what the polling items are going to be, because it's 4 o'clock. Staff is going to want to get out of here on time today, so let's give them some direction. Lana.
Yeah, I was just going to ask. I know that you had asked at the beginning of the meeting if anybody had anything to say, but we went through a lot of information today. And I think that it's, you know, we're sitting around the table saying, you know, we're here for the members and we're representing them. I just think to open it up to let anybody that did take the time to be here throughout the entire day with us, if they had something to say. Maybe they don't, it'll go quick, but maybe somebody does have something to say.
Well, I will tell you what, I will compromise with you, and after we're done polling, I'll call on them, and that's how we can do it from here on forward. We can call on the membership at the beginning of the meeting and then at the end, but it's hard enough controlling 12 people. I can't control an audience too from up here, so we got polling on the branches. What else do we need direction on, Aaron?
Just if it's acceptable that I pull that legislative type language out. It'll be red lines, you'll see it. It'll be struck through so you'll see it. Make those language tweaks to clarify and get rid of ambiguities. Share it with some of these professor types I've mentioned. And then right after the Christmas holiday, come back with what would look like a fairly clean document. I'll do it in bubbles, so everything that's been taken out will be on the side, and the body will be black. And then the next phase would be to go through those areas that remain in conflict. In those areas we discover, as we go through that review, that'll be allowed to happen. Then right after the holiday break, we come back with that document and do this again.
Okay. All right, so we're going to do polls, no soapboxes, especially for me. You won't hear me talk about it however it goes. You're not going to see me on the internet about it, nothing like that. That's my promise to you guys. So when we poll, just say 3 or 2. And then after that, we'll do a separate poll, yes or no, to give Aaron the time that he's requesting to consult with the attorneys. So do roll call 3 or 2 first.
Okay, can I do? Thank you. Okay, Bridget, I'm sorry, I do have to ask a point of clarification. If they support both, is this the time when they should say 3 or 2?
They just say 3 or 2.
Okay, so one or the other? I thought,
That's either or though, but there's some people that said they'll do it either way.
right, and you guys had talked about doing the poll. You
to make
support
it-
3, you support
You
2.
just have to make a decision, you know?
Yeah, I think we should.
How do you support both, but then one or the other?
Because if like Mike said,
I'm sorry.
I would rather it do, but if three's the way.
We can't hear what's being said.
Basically an abstention.
Do you pull a mic?
Compromise?
Yeah.
Why don't we do, let's see if we even have enough for 3.
Okay.
Then let's go to 2.
Okay.
Then let's do, that's it. Actually, that's all you got to do.
So this one's going to be on, do you support the 3 branch? The next poll will be on, do you support the 2nd branch? And then the third one is going to be on allowing Aaron to do everything that he just
Yeah.
listed.
Yeah.
Okay, so the first one is, do you support the 3 branch?
Simple yes or no.
Okay, there we go. So Bridget,
Can I ask a question?
Technically not supposed to, but go ahead.
I mean, well, Aaron just said something, but, well, here's the thing. I mean, I still don't have enough information to say or 2 or 3, so am I going to be held to that in a court of shame?
Can I tell you something? So this is just to give Aaron some direction for how he works with the attorneys to work on this. This isn't the vote to send it out or anything like that. You know what I mean? So this isn't binding. You can change your mind down the road. So Aaron.
I can make it easy.
Yeah.
Forget the 3 or 2, just let me do the work. Give me a poll on doing the work, I'll
I
bring it
don't
back.
agree with that.
You guys don't like
That's
the
what
3,
should happen.
then you
I
can
don't
throw it
agree
away.
with that. I don't need to know whether or not I need to participate anymore.
Just finish the poll. Yeah, we'll do
okay,
it.
so we're doing the poll on the 3 branch? Yes. Okay, Bridget,
Both.
Oh, that's acceptable.
What happened?
She said
Okay.
both.
she did say both. Kimberly Gravel,
Abstain.
Tyler LaPlante,
Both.
Isaac McKechnie. Both. Kimberly Lee,
You're muted.
He said both.
oh, okay, thank you. Michael McCurchy. Sean Borowitz.
3.
3 only. Okay. Kimberly Hampton. Kimberly Hampton? We can't hear you. Rob McGrory.
3.
Lana.
3.
Aaron.
3.
Larry.
3.
Kim Hampton, did you want to try again? Maybe text, yeah. I don't,
Kim just texted me and said 3.
3, thank you.
Mr. Chair,
She said both, but 3 if you
Okay.
have to choose one.
your preference, Mr. Chair?
So,
Your preference,
oh yeah,
Mr.
you would
Chair?
get to vote on this. In the,
I don't know. So 3, just have them look at the pros and cons of 3 branch, if they think it's a dumb idea, if it's going to be overly cumbersome, have them state that. If we're going to have a chair, like Matt Weesaw from Pokagon come in that exists from a tribe with 2 branch, we want to do that, just fly someone in with a 3 too, it's fair. Examine both sides of it. You should know you're going to be paying for them to come here though. And who knows if it works with their schedule. I don't need to have either one of them here, you know what I mean?
I think-
But if you guys want to, it's totally fine. We can figure that out. Aaron can. So
for the
are there any objections to giving Schlehuber enough time to look at this? It seems like there's consensus to do that now after having this conversation. No objection. Don't take all year, but take the time that you need to do it accurately and thoroughly, okay?
Good.
so are we going to set the next time, or are we going to wait till he tells us
Oh.
he's done?
We are going to wait for Aaron because Aaron is going to do this job the right way.
I'll give you updates as it goes forward.
Okay. Anything else, guys? Okay, hearing that, does anyone from the membership want to say anything? Okay, so go ahead, Colleen. Dr. Ford. You just have to unmute yourself.
Oh, I'm sorry. I lucked out today by going on Facebook and noticing this meeting was happening, so I missed that initial invitation to speak. I'm just so I feel warm and fuzzy and wonderful. I think this was a wonderful first stab at the new Constitution, and I commend all of you for your work and your attitudes and the whole works. God bless you all.
Thank you for that. Bill Peralt?
How's it going, everybody? I just wanted to chime in. I was trying to chime in earlier because of the one section about immunity for the tribe. I think that needs to be defined for the citizenship, so we don't have Bill Peralt out in the middle of Austin Lowe's hunting area claiming immunity because he's part of the tribe. And then outside of that, I want to thank you guys for the very uncomfortable conversation that you guys have to have. It's unnerving. I can tell it is. And finally, I hope everybody goes for both. Whatever succeeds is probably going to be the best. Give me glitch.
Thank you. Nancy?
Yes, thank you. I have a couple of comments from listening mostly early on. I mean, there certainly is a lot to absorb, so I can understand why Rob might have wanted to have another session. It's a lot to take in on one day. But my immediate concern was the discussion about there's too much detail in this draft. I've reviewed quite a few 3-branch government constitutions and 2-branch, and they do contain an awful lot of detail. I understand wanting to legislate some of the things, but of main concern to me was when it dealt with the judicial branch. The legal counsel recommended eliminating the details regarding the jurisdiction of the court and the powers of the court. And if you leave that to legislate, then what you are really doing is giving the council then back the authority over the courts. Because they will be legislating what those duties are. To me, that seems like it's very inconsistent with the whole notion of having a separation of court. Now, I could be misunderstanding that, but if you take them out of the Constitution and have them legislated, then they are not constitutional rights. But at the same time, the council stated that the duties of the council need to be specifically stated. So again, that seems like a contradiction to me. It does seem that what this document is now is very far away from what the committees proposed and what in 207 and then again in 2012, it seems like now, I don't mean to be offensive, but now it seems like a constitution written by the tribal legal department and is no longer a work of the members. And I think that that needs to be considered because it is far away from that original document. They added detail in there because they wanted it in there. And I just think that that needs to be considered. And I do appreciate all the hard work that Rob has put into doing this. And one final note, whether you like it or not, I don't appreciate having the members' right to referendum being referred to as governmental fat. I think that was highly inappropriate. And that is the end of my comments. Thank you.
Thank you. Anyone else? All right, I don't see any more hands up, so I appreciate all the members that attended, and I appreciate the board members here as well. So this is just the start of this conversation, and we will keep having it. So thank you, everybody.